Good morning, good evening, good afternoon, good whatever it is, wherever you are. And welcome to this day 5 in the Iowa versus Brammer case. It'll be closing arguments. Both sides rested yesterday after we heard the special medical examiner called in from to repudiate the fact that the state's own medical examiner couldn't find any evidence of the cause of death. Yeah, it's live. I even went early live. We haven't got a verdict yet. I'm wondering because there will be a sentencing in the other case that Dave has been covering. Do you want me to pull that up as well, Dave? You have a link. You can always come on if you want to do that. Yeah, it's morning there. Hello from the morning. But YouTube is a global phenomenon. I've even heard that in parts of Europe they have the internet. So it's afternoon here, and if you are, no one is living in Australia. Let's just be honest. It's evening over there, even night, I believe. So you can live other places in Asia as well where it's night, or if you live in Central Europe, it's night, evening. So I was technically correct by saying good morning, good evening, good night, good whatever it is, wherever you are. I'm talking about people who are in New Jersey. Hey, Christine. And Iris, I'm not sure where she's from. Parts unknown, just like The Undertaker. No, he's from Death Valley. It's Mankind who's from parts unknown. Good morning, Rob Mill. And I can say chat. It's Nick who has the problem with disease. Good morning, Kim. Hola, Iris. Welcome. Good morning, Tina. Tina? Danny T. Yep, it's one of those days. Good morning, Miami. Welcome, welcome. Wicked Psyched is up and running. Little Peanut. Oh, it won't be. Okay, I just saw that they had over at Lawn and Crim. So we can't do sentencing in that case. That's a weird case that they couldn't broadcast that. But you call the court and yell at them. Well, I have a lot of beef with you. I have beef with people who are too nice and too sweet. That's why I have beef with Jamie, and that's why she's not shown up yet. You can have a little piece of beef with me. I've said when Brandon and I go tailgating in Texas, you can show us the good spots. Good morning, Stacy. Welcome, welcome. And this stupid cold better soon get away. Oh, the judge is scary. Well, come on and drink half a beer, and then you can call them. Hey, Rain. But no, yesterday was mostly the battle of the medical experts, because the state's own expert couldn't determine how she stopped breathing. But this very special Dr. Brammer, he's a famous ME. He could clearly tell that she had been choked, and it was kind of odd because on direct, the state's ME was asked if she could see any signs of that, and she said nope. So yeah, I didn't. Well, Dave, it's 2023. Women can wreck a vehicle as well as a man. Hey, atheist. And Jude. Dr. Barton, that's the name. I was only watching most of his testimony, but I found it weird that they had to call in an expert to disprove their own expert, especially because their own expert kind of was good for the defense, in my opinion. Good morning, Josie. And Carlene, welcome, welcome. So I thought it was kind of weird yesterday with the battle of the MEs, and that's probably it's kind of funny whenever we watch trials, we go into this and think, oh, this is a slam dunk. Talking about a slam dunk hoodie.
Hi.
I just called you a slam dunk hoodie.
That's a new one.
Morning, Valhalla. I tried to. Danny tried a rear naked choke on her husband and it didn't work. Well, just squeeze a little bit more. Just say it's a love squeeze. No, but Jamie, you stuck up to the end yesterday.
I did.
And the state's ME was kind of good for the defense.
Yeah, the first one. The second one was supposed to destroy, but he was the worst.
Yeah.
Yeah, they said undetermined. Okay, bye.
Well, it's by order of Irish.
What?
Read the screen.
Oh. Honey bunny.
All the hate. Hey, Murph Turf.
She didn't say she didn't want to see yours.
Well, she said that was the beautiful face she wanted to see.
We can share.
Yeah, they both agreed that was ligature marks, but especially the state ME talked a lot about the long ligaments you had in the neck, that there wasn't sufficient marks on those to imply that she had been strangulated. He talked a lot about the pressure of a forearm and stuff like that, but he didn't seem that certain. Or did I just only see parts of it?
It was so wishy-washy.
Yeah,
Because
to me, it didn't come off.
He kept harping on was that she had these teeth marks on her neck, and it had to be because there's not on one side, it had to be the soft part of the coat and then the teeth part of the coat, and he must have had it in a grip, you know.
Yeah, and that didn't really make sense to me. Yeah, I did have my Billy Idol cut back then. It was a lot of that wax.
It's so cute.
Yeah, I was a lot of wax in that hair.
Oh.
Even after I took my beret off, it would stand right up again. No, that old guy, he seemed more like a hired gun than he seemed like he was doing a fair assessment. But I could be wrong because I only saw him. I think I saw up until just before cross. Then I fell asleep. Yeah, the zipper teeth. That, and again, the shirt up, and then that still.
Well, he was talking about like you could pull it from behind too, like if you got a hold of it from
Yeah,
behind.
you could do that, but then you would have
had it zipped up.
Then you would have clear, kind of like rope burns.
Well, he kept harping on the fact that like there was no bruising, because that's what she said too, was no bruising on the neck. So that's why with the soft coat you could totally get no bruising.
Yeah.
I don't know.
Yeah, but she was severely pummeled in some way or another.
Oh yeah, like once they said knees, they said there was bruising on like the knees and the ankles and stuff. Explain that to me, because I was sitting there thinking, Well, from their timeline, they were in the car a majority of the time until she was not in the car anymore. Where did he beat her from head to toe? And if he did it
Yeah.
in the car, explain it to me. It doesn't really make sense. It would
No,
make
that's
more sense that she got hit by a car.
yeah, that's the problem. Did did he do it outside of the car, or did he do it inside the car?
Mm-hmm.
It really didn't make that much sense because again, if you can beat her so severely, there's not much room to fight in a car.
Yeah. And then if they're trying to say like he choked her out first and then beat her up, I don't know. I don't know. I know people do crazy things, but it's hard to wrap your head around it.
Yeah, and to the Mo Raiders, welcome, welcome. Hey, Dennis, Farm Girl. By these trials lately, I hope I'm not the last one known to be with someone before they're alive. They just cram these cases to fit. Yeah, and that's my problem. They just go by the first one we point at. Let's prove it's that person.
Mm-hmm.
There's a lot of circumstantial evidence. They're riding around in the car and picking up the safe and going to the side of the road in only 3 minutes and back again. There's a lot of stuff. The phone. Um, so I'm pretty sure that he did do it. But again, if you need um, stupid cough, if you need so much circumstantial evidence, yeah, that's weird. Hey, Peach
Well, they said
and
the
Wolfram.
phone was shut off. They harped on the fact that the phone was shut off at 10:56. Sorry, I have a page of notes.
Yeah,
So.
10:56 to 11:11, and back
But
again on
turned back on
12:36.
10:56. It was off. 11:11. It came back on. 11:20. It went off again, and then 12:35. It was on again.
Yeah,
But
it's probably all the dry humping.
but according to their timeline, they were driving in the car the whole time together. So
Yeah,
I don't know.
yeah.
But if you're turning it
Did,
off to like evade people or seem like you're not together, why would you turn it back on like a few minutes later? It's not. It just seems stupid.
yeah, but there's not many smart criminals who end up in court.
I know,
Yeah,
but
he could have. He could have. Were there any talk about the bruising happened pre or post mortem?
no.
Because bruising would suggest bleeding, and bleeding only happens when there's a little pressure on the system. And the second your heart stops, there's no pressure on the system. Then you will only get the blood traveling to the lowest part of the body.
Nope, she didn't
Uh,
really say anything. A lot of it was just what she saw and the fact that she couldn't determine a time of death or the cause of death, really.
yeah, that's what I heard as well. Yeah, it's tough when a whole state is against you. Don't even get me started on taking on a whole country. Yeah, that's uh, that's the big problem. The state have all the monies, and if they point the finger at you, good luck. We have seen it in so many cases, especially the Zachariah Anderson case, that they'll just steamroll you. And
Oh,
truth may be what truth is, but they have enough money to prove you're guilty, especially when they can go out and hire Dr. Brammer. Uh, why can't I remember his name? Because he's not cheap. What was his price? 17K or something
80
like that.
8,500 a day?
Yeah, and that's normal. Yeah, but is it normal to call in and another ME when your own ME testifies? That's the one I had a problem with.
Well, as the family, they believed it was foul play. So the family contacted him first.
Well, and that's part I actually thought about, and that's I don't know if Dave is in court, in chat, because when Branka does his self-defense defenses, the parties can't contact him. It's the lawyer who has to contact him. So can the family just reach out and say, "Oh, we think she was strangulated," and he says, "Yeah, I think so too." "Oh, we'll have our lawyers call you, or the state call you." To me, that seems kind of fishy that they had a second ME, but maybe you can. What do I know?
Well, they said they had said that once he can't come in until the state ME does what they do.
Yeah.
So once the body is, once they're done with what they're doing, the body goes to the next of kin. So once they have possession of the body, they can do whatever they want. So maybe they reached out to him, paid him, he looked, and because of what he said, the prosecution took over, whatever. And
Yeah.
man,
I don't know how it works, but
that's what I assume happened, because if they said that the body is theirs to do with whatever they want, maybe they wanted a second opinion and they paid for him to reach out, and he gave a second opinion, and it was like, oh wow, this is different. So
yeah, it's just that Wilhammer has the stream up and running with the good audio. Let's see if I can find that one. I just noticed that Branka always say that he can't be in direct contact with the defendant. It must be the lawyers who contacts him.
yeah.
Then I can take away because he has already put one up. I can move this. Yeah. So that's I just find it funny that they go out and shop for an expert. Yeah, because as I've said, I have a few days in court a year, and some people really, we don't have the Fifth Amendment, but we have the same right, and some people really should stop talking. The defendant seems soft, but the state's theory is stupid. Yeah, they're beating up so severely in a car. He could have done it outside, but they can't prove it.
Well, and he said, like, because they were reading off all the charges yesterday and like what they proved. And they proved, like, this is why Dave uploaded the interrogation, because I was going to look through it, but I didn't because I'm lazy. But to see what he said, because they said that they proved that he stole the money from her, and that he stole her shoe, and that he stole the safe. And I was just like, when did all that come out? Because I didn't hear any of that stuff. Because yeah, she had the safe, but I didn't hear anyone testify that she had exactly $1,200 in there and it was missing.
Oh, yeah.
The daughter testified that she kept money in the safe, a social security card, a birth certificate, but the last time she had seen it was like before Christmas of 2022.
Yeah.
I spent hours editing the video specifically for Jamie. Hours of my day yesterday, like 7 hours, trying to fix that audio, and she didn't even listen.
Sorry, I went to bed and I didn't have to work today, so I didn't set an alarm, and you better believe I didn't wake up until like 10 minutes before I had to get on here. So
I believe you woke up 10 minutes after you were supposed to get on here, but that's just,
yeah.
technicality. No, I didn't spend hours on it, but I did upload it. And if you guys want to, I think I enhanced the audio. I kept like enhancing it and then listening and then enhancing and listening. I didn't watch the whole thing, but I was just listening for his voice to make sure that we can make out what he was saying in that interrogation. So hopefully it's actually useful to you guys. I'm not VO Hammer. I don't know the magic tool.
Yeah.
But I hope I did okay. I just wanted to pop on and say hi and shame Jamie for not watching the video that I specifically told her I was making for her.
Yep. maybe on break time I'll pop through it. But
I just the expert thing, because with Branca, if you hire him, either side hires him. Probably not the state, because they're not so much interested in the laws of self-defense. But if he comes in to testify, he says you can't reach out to him. It must be your lawyer. You can't retain him. Only your lawyer can. How can the family retain an outside ME and bring it into the case?
What do you mean? Oh. Well, because you have it's different, right? So you're retaining Dronka for the purposes of litigation. You might not be retaining the medical examiner for the purposes of litigation. Like you can always get a second opinion on a medical examination or anything like that. So sometimes families do hire MEs, independent MEs, because they're not sure about what's going on. You can hire an independent ME to do an examination. But it might not necessarily be specifically for the purposes of litigation. And then when you get a different result, you're like, oh, hey, I had a case. I don't know, I can go into too much detail, but woman believed her father was poisoned to death by her stepmother and stepsister. And he was older and he had some illnesses, and so there was never really an autopsy done. He was married at the time. But the daughters requested a independent medical examination, and then they do what they do with that information. I'm not going to talk much more about that, but it wasn't necessarily for the purposes of litigation. It was just, is that really what happened? And then I'll just say there was no subsequent litigation, but for peace of mind, they kind of wanted to know what exactly was going on. So, so there's various reasons to do it. And if with that information, though, this is a factual sort of information thing, but you can be a fact witness as well as an expert witness. So you can be both. So that's my sort of scenario. But Branca would be hired specifically for litigation purposes. And so it would be appropriate for the attorney to reach out to him, not the client. The other thing is that he doesn't represent people. So even if the client reached out to him, there's nothing he can do because he doesn't represent individuals. And that's just his choice.
Yeah.
yeah, because
Thank you, Irish. Hola, amigos. Baker and Jamie from Shishi MG Law Talk with Mike, Mo in the Deep End, Jessica Reluda, and others crew. Oh, yeah. Hi, Dave.
You know what? If it keeps the grip going, Iris, I'm cool with it.
Yeah, keep beefing with Iris. That's thank you so much, Iris.
yeah, that's what they had said yesterday, was that once the state ME is done with whatever she's doing or whatever they're doing, then the possession of the body is to the family. So then the family's allowed to do whatever. So they're the one that reached out to him. So.
Oh, so she's probably getting 50 years.
And
this is the update I'm getting on Armstrong.
Oh, that's that's life sentence.
She's 30 something.
Yeah.
What?
She's 30 something years old. So 50 years would mean she has a chance of getting out.
B looked 50.
Well, yeah, she looks 50, but she was 35 at the time of the unaliving, so that would put her in her late 30s. I mean, there's a chance, right? Assuming she stays healthy and in prison. She's a yoga instructor. She's going to stay thin and healthy.
So is Jody. They can put on workshops.
Yeah. Oh, wait. Oh, no, it's Texas. I was like, can they be friends? But no, they're different states.
Well, they could do a transfer or something. I don't know. But no, but Jamie didn't like the way Dr. Barton came off. Did you feel he was a good witness, or because I felt like he was getting old?
Yeah, the little bit that I watched, because when he took the stand, then I had to jump away and go take care of my horse. But I did watch some of it, and the parts that I heard, he seemed to be. There's a lot of speculation, a lot of conjecture. He said, "I think this." When he was asked on Cross about the zipper marks, that's really what I paid attention to a lot. He was asked about the zipper marks. He claimed zipper marks on the neck,
Yeah,
and how did you compare them? Did you like line them up like mark for mark? And he's like, well, no, I just sort of observed it. It's like, well, why don't you at least, take a ruler? I can give you one, and you can
yeah.
like measure the distances or something. So
Because,
it all seemed very
because
suspect to me.
every zipper has some kind of different length between the teeth.
Yeah,
But
there's like 4 or 5 different standard sizes, and there's not that many. Is kind of my point. And so you could easily just measure and determine, like this right here is a really fine zipper. It's almost like Velcro. It's really fine. If this is the type of thing that she had on, but the marks are more spread apart, where it would be consistent with the zipper that say is on your coat, that's uh, that's an issue, right? And to say you didn't measure, you just sort of, I looked and they looked similar. It's not very scientific to me. But who knows what the hell the jury's going to believe anymore? I
no,
give up
and
guessing.
again, if you, as I understood that, either pulled the shirt back or had her in a rear naked choke,
Yeah.
would you have a perfect indentation from the zipper, or would it be moving a lot around? It's, to me, that's
Yeah.
yeah. Iris wants you to take it off so she can see it. Oh,
Yeah, I'm not going to model it. This is by the way, look at that. See? This is my 10-year
oh,
anniversary shirt for my law firm, Home Law, for all your litigation needs.
Did you make it for yourself?
I ordered like 40 of them.
Well, isn't that precious?
so he has
You
39
guys like the
pieces.
flowers that are behind me, by the way? They've been moved.
You got flowers? For what?
No, they were here on my conference room table when I got in this morning.
Oh, they're pretty.
They're fake.
Oh, I love fake flowers.
Yeah, I'm sending them to Jamie. That's what's happening with these things.
Well, fine then. Give them to me.
Yep.
Yeah, don't wrap
I'm
him
gonna
up with
personally
the.
deliver them.
Don't wrap him up in a PC, because you don't want no PC. We need to do a griftathon so we can raise funds for her new keyboard and side table.
Fine.
These are so no, like they might look okay on camera. They don't in real life. We'll just say the edges of these canvas flowers are like fraying and touch. When I walked in, I was like, "Is it my birthday or my funeral?" Because that's what it looks like. It's they're
It's a lot
they
of
look
flowers
pretty in
for
the
a guy.
background, huh?
It's a lot of flowers for a guy.
Yeah, yeah. No, they were actually. There's another attorney in my office, and his client gave them to him as a thank you for whatever he did. And he's like, I didn't know what to do with them, so he stuck them on the conference room table.
Peace,
Like,
Albert.
oh, okay, cool.
But this trial is just like the Texas trial. They never start on time.
Yeah, no, well, when they say at 9 o'clock, I want the jury here. That doesn't mean that they're going right on at 9 o'clock.
Well, the car case we covered in Wisconsin, he said be here by 9:15. We go by 9:30 or 8:30 or whatever, and he started a minute or two early every day.
Nice.
So,
I
that's
prefer
pretty
that.
nice.
I'd so much rather go earlier on just about anything.
Yeah, because especially when you're just sitting here covering it, you can say, well, I'm gonna do a recap of yesterday. That about 10 minutes. That'll fit. And now you have that's 20 extra minutes we have to fill time, and it's just annoying that people don't think about us. Another thought I had yesterday: if she was lying on that zipper, it would make a similar mark on her skin.
That seems more likely, right? You ever wake up on a pillow with some texture to it, and like your face looks like that for the rest of the day?
Yeah, I was just at my masseuse. She said, "Oh my God, what happened to your back?" And I thought, "What?" She said, "It's filled with these round marks. Did you get that
The
Chinese?"
backrest on the chair.
And I don't know, what could it be. Oh, we have some heat benches in. We have a little spa section in my gym, and I'd been in there just to get warm before I got my massage, and they had little knots on it. So it was that, but I didn't think about the markings it would leave on my body. She was, "Oh my God, what happened? What happened?" I don't know.
You were being unalived, Baker, and you didn't even know it.
No, yeah, there were some sketchy guys in there. So
Imagine if you had like died recently thereafter, not you personally, but someone had died recently thereafter sitting on that, and the medical examiner is trying to figure out what all these little marks are, and it's just because he went to the spa just before he died, and or
yeah, and
the
then
sauna.
got run over outside of the gym. No, it wasn't nut marks.
Yeah, that's what
That'd
you
be
said. That's what I heard. You had nut marks on your back.
no, those are normally on my forehead.
Oh my God.
Jamie, did you
On
notice
that note,
anything?
I've got to do some work. I just wanted to pop on and shame Jamie a little and see what you guys were doing.
Yeah, everyone wants to see Jamie today.
Here I am. Here I be.
Hi, you're wearing the wrong colors though.
Nope. That's how it.
Jeez, you just you're.
What?
I feel I'm a little concerned with you being a Michigan fan because I feel like it's more of a I'm going to follow the crowd sort of thing than I'm really a fan.
No. I grew
No?
up on it.
Okay.
My family is split. It's not just me. Like, it's not just because everybody in my family is. My family is very split. It's funny.
She's wearing MLS colors. She is kind of. Well, it's dark blue. It looks black.
But you'll be ready to go at 7? No, not 7. 1 your time.
To my time. To my time.
Yeah,
Yeah,
so
I'll set up
one
a link because I'm going to go on
one,
layback
one
news at noon.
yeah, so 1 o'clock their time.
Yeah,
So
one
that should
o'clock their time.
yeah, we'll probably be on Verdict Watch, but we keep the boat a rocking, so you can take over at 2.
Sounds good. You guys will see me play video games while we wait for a verdict. I don't know what
Yeah.
else to do. Well, you know what? If you guys don't stream the quality video that I produced, we might actually listen to that.
I mean, we have to now.
Right? I spent
You
so
have
much
to.
time on that.
Oh,
Yeah.
don't even get
But
me started.
don't hold it for me. If you guys want to watch it, go ahead and watch it.
No.
Well, we just want to watch the closing statements.
Well, but then you got Verdict Watch. You got time to kill for Verdict Watch.
Well, I tend to go off on a tangent and talk about crazy. Remember, I'm a pro at Verdict Watches.
That's
I'm
you
the
are. You are.
I am the prolific Verdict Watcher.
You're way better at
35
verdict
hours.
watches than me. I shut down my streams. I'll be like, I'll go live when there's a verdict. That's what I do.
Yeah, but you're smarter than I am. That's why you are a lawyer and I'm a baker, because I just sit here and talk. No, today
Oh,
I have
Paris, you sent me the honeydew list. Okay, good.
I have I have we should be qualifying for the European Championships tonight. So I have to go watch my football tonight. Jimmy's
That's
always
a
fast.
long list. That's a long list, Aries. That's all I'm gonna say. No,
What?
but yeah, no. She's keeping tabs on me.
Oh, it's just Jamie's growling.
Mm-hmm. You zip it.
Who, me?
What happened?
Hey, Mr. Goldman.
What's going on, brothers?
Does he have control
Yes.
over your streams too, or is he?
Not
Was
yet.
he
I'm getting
invited?
there. I'm getting there.
That's the next thing he will put in the YouTube TOS is
I must have
He
access
must-
to everybody's StreamYard.
yeah.
We will never deny him on panel ever again.
Never.
He's done collecting wrenches. He's moved on to the next.
Yes.
Collecting StreamYards.
I've evolved.
So I'm switching over to Streamlabs now.
Oh,
We're done with StreamYards.
oh. Shit.
Well,
I got to figure out how to invite people onto my Streamlabs. I don't know how to do that yet.
I understand. From my understanding, Streamlabs is much more difficult to have multiple people on.
Yeah,
but I don't know.
Well, you gotta set up the screens ahead of time. So I gotta set up like video and me, or just me, and then I gotta set up a video with 2 people and a video with 3 people, and whatever. You gotta set it all up manually. You gotta switch between the 3, which is fine.
Horrible.
It's fine. It's not that bad actually once you start doing it, but
maybe,
I don't know how to
we-
send the invite.
You need to
Maybe
talk
read-
about it.
You can talk to Reloaded. She does it.
Yeah. She does it, and she has all those fancy bots and all that stuff.
Ricada
Yeah,
uses
I was gonna-
Streamlabs too, I think.
Yeah, her and I were talking. We're gonna do a thing, and we're gonna do like a little private conference or something, and we'll work it through.
Yeah.
But Rackets use StreamYards when he has guests on.
Yeah, because it's much more difficult to use Streamlabs.
Yeah,
I think.
But see, if I wanted to do video game for a verdict, I have to use Streamlabs. But then if I wanted to switch over,
you can
and invite people on.
you can share screen.
But
Because
I don't get the sound.
I looked into it, and some people say you can do that.
Oh, that's
Because,
true. Mads is right. He does. Ryan, the editor, I think, runs all of his stuff, but I could be wrong on that.
Yeah, he
Oh.
got backdoor pass, but still, when he has guests on, he uses StreamYards. He has said that multiple times. That Streamlabs are annoying with guests on.
I would prefer just to Streamlab by myself and StreamYard when I have guests. But I was trying to figure out a way to play a video game. I just won't have the sound. That's all. To the video game. That's the problem.
But you can't have video audio either way. You'll get copyright struck with that.
No, I've done a couple of test streams. I haven't been struck at all.
Hey, Wendy. No, nothing has happened. We are waiting for closing arguments, so we are just filling time and talking. So nothing has been missed. And while I go get me some cough drops, could you give a rundown of the case? Because I saw Thierry hadn't watched this case.
That's on y'all. I've only caught a couple days of it.
Oh. Well, Dave, are you leaving then?
I'm leaving.
Okay.
Fine, be
work.
that way.
So Mr. Ivan and Eileen have been in a relationship for a couple years. They broke up about a week before she went missing. She was staying with a man named Mike, and he dropped her off at work that morning on the 13th.
Don't forget Mike's favorite hobby. He likes to dry hump.
Well,
Mike apparently was dry humping the victim.
according to Ivan, Mike likes to dry hump, and he raped her, but there's nothing. Mike testified to them not even having a romantic relationship. So he
Well,
slept.
I mean, to be fair, you can dry hump something you don't have a romantic relationship with.
I know, but I'm just saying, like, he testified that he slept on the couch the whole time and she was in the bedroom. But she only stayed like a couple days. But anyways, he dropped her off that morning to her job at Sugar's, this, which you would think is a strip club, but it is not. It is a lounge and diner.
It's like a backcountry watering hole with a, that also serves food and has a dance floor with some live band every once in
It
a
looks
while.
like this hometown bar that I used to frequent.
It just looks like a little dive bar. It's
Yeah.
cool.
Yeah, Josie. Look at what Josie said. Don't forget about the earring proposal. So she proposed. She got down on one knee and proposed to him with a diamond-studded A diamond stud earring.
Hey, I stand by the statement that a diamond is a diamond.
Yeah, well, all the kids, because, well, don't forget that they started dating and then their children started dating. So,
Oh yeah, forgot about that part.
and
I'm gonna go
around
get a coffee.
Christmas time, she bought a diamond studded earring and she got down on one knee and she said, "Will you be my man?" And he said, "Oh, stop it."
Oh, stop it.
Yeah. And so that was that. But anyways, the whole point is Mike dropped her off that 5:30 at her job at Sugar's to do clean, and then 8:30 he was picked up by the defendant, and they drove around. And well, his story there changed quite a bit, I will say, but he claims he dropped her off at Mike's and he never saw her again. But about
Well, the police claim his story changed, but we have not really properly watched his interrogation.
I know,
because I just edited it
things
and made
were
it.
and he did add things in. I mean, I agree with you 100%. But basically, 11 days later, she was found in a ditch.
Half eaten by animals.
Yep.
Looks like I have a pyramid behind me, doesn't it?
Oh, kind of, yeah. It's just somebody's house. Or is that the
It's a
tree
Greek
house?
No, it's a Greek Orthodox church, but this angle looks like a pyramid. I'm in Gaza, y'all.
There you go.
Covering the war.
Yikes.
So, yeah.
There's a lot of weird stuff with this case though. Like somebody hired a medical examiner and they didn't like what they said, so they hired another medical examiner, and
yeah, that's
original medical examiner. Death was undetermined. They couldn't. They didn't see any evidence of strangulation, anything like that. There was a lot of bruising, like all over her body, head trauma. She had ankle bruising, knee bruising. So what they would think is beating from head to toe, but I mean, I don't know. But then they
or consistent with being hit by a car on the side of the road.
She was strangled, so it's kind of confusing.
The flowers are halfway in the box on their way to Jamie. Yes.
And the state alleges that this guy was driving around with her deceased self in the truck and went through Burger King's drive-through and all kinds of craziness.
Yep, he's on video multiple times throughout that day because he did pick her up and they drove around. They went to Omaha to get cigarettes because they're cheaper there. He actually, she went to her mom's house to get a safe that she has where she apparently keeps her money and birth certificate, social security card in it. So he took her there. They're on video. She's alive then. And then they go to another apartment complex. He is trying to get an apartment because she's, getting kicked out of Mike's house. So she's alive then. And then they're driving around. They went and got some cigarettes. And then apparently between around 10:30, he offed her and drove around with her dead body for multiple hours. Went to Burger King, and they claim that they see her, unalived in the passenger seat.
But all they showed is like they've got one image, a still frame out of this video of like a thigh in the passenger seat. You can't tell anything. You can't even really tell it's her.
Position, right back. Bahala. It's very unnatural for her legs to look like that, apparently.
I spend about 23 hours a day in an unnatural position.
I
know. I was talking about the spanking case the other day. I actually have a news clipping from my case right there on my wall. Jury finds stepmom not guilty in spanking trial. And look, there's a picture of me with the accuser from the trial.
Or accusee?
Accuser. This is bio mom. I'm cross-examining her vigorously.
Oh God.
I love it.
I just saw it in the background behind me.
I don't understand in this case why they didn't call the Burger King drive-through guy. It doesn't make sense.
The defense could have called him, but he would have been like, I don't remember anything about anything because there was nothing suspicious. That would have been a good thing to.
The defense should have called him then.
Do you think
Yeah.
maybe they talked to him and they just didn't feel like his information was?
He probably has no.
Well, that's true. They could have talked to him, and then he could have been like this loser stoner dude, or he could have had like, false memories based on news media. Who knows? Like, there's a lot of people that I talk to. I have a list of, prospective witnesses for any given trial, and I talked to all of them. And if you remember my MLS Goes to Court trial coverage that I did, and I said I have one more witness. I'm going to step out and call them and see if we need to continue this to the next day, or if not be. Well, I called that witness, and after talking to them, I was like, no, I'm not going to call you to the stand. I don't think it'll be beneficial.
So this is the thing. I'll just break it down since they're going to it. Never mind.
Yeah, you can keep talking. You got time.
Okay, well, she was picked up at 8:32 at Sugar's, and they're seen driving at 8:37. 8:45, she's on video going to her mom's apartment, so she's still alive. So I was trying to figure out, like, okay, when is she still alive and when is she, So we got 8:45, she's at her mom's apartment getting the safe. 8:51, she's leaving. They see her leaving. 9:13, they show her on video at the other apartment complex, inquiring about apartment. And then they show them driving at 9:20, 9:22, 9:28. And then at 10:26 is when they claim this is now unnatural for the way she looks in the car. See, 10:30, she said
It's so loud. Baker, come back and turn the court volume down a little bit, man.
So I don't know because 10:30 they claim that's when she's done. She's dead skis. So between I guess driving, because 9:20 to 10:30, that's when but they're driving that whole time. They don't show, there's not really a time frame when they were like, not driving. I mean, I guess 9:28 to 9:26 or 10:26. So like for an hour, if they didn't have him on video, I guess he could have stopped and done it. But it's so weird. It's just weird situation.
Before we bring the jury in, let me inquire counsel with respect to audiovisual. Are you going to be using your screen, I'm assuming? And Drew?
Judge, I intended to take their record when they're done and plug it into my laptop and left turn, so I'm not trying to drag this over here.
All right, so
what should I get
will be
for
on the right table as far as I'm concerned. I'm going to do that now, so there's... I don't know if that's your screen or not, Paul.
You don't know what I said?
No.
Oh, I said, what should I get for breakfast?
Steak and
McGriddle.
Ordering in.
That's how you're going to be
No, no.
What I'm going to do then...
McGriddle, really?
That's clear, but
Steak and
it's ready to
eggs,
go.
man.
As soon as
Steak
I
and
finish
eggs.
instructing, I'll put that on. And I do intend to instruct the jury as to the law prior to your argument, and then I'll introduce you and you'll argue. All right?
Judge, 38,
Bob.
you're numbering the bottom where that means the instruction of 39.
Like a country breakfast scramble. Yum.
Hang on.
I do like me a good scramble.
I do too.
Thank you, counsel. All right.
The male medical examiner, I know you guys were talking about it right before I got on, but I don't think he's got that right. I don't see how that could work.
Yeah.
This theory. It doesn't make sense to me.
Anything else before we bring the jury in? Claire?
Your Honor, he's Paul will be given the first argument. I'll be given rebuttal. Just-
Did you say rebuttal or butthole? I'm pretty sure he said rebuttal, but that's not what I heard.
Rebutthole.
I thought he said her butthole.
Her butthole. Oh God.
Flux and I are doing a new show tonight at 8:30.
Can you say something to me? Make sure I'm connected.
What is it?
Yes.
Melting Point. It's going to be a bunch of crusty old vet stories. It's going to be good.
Crusty old vet stories.
I like
Hear
it.
that, guys?
At the moment, it's on her channel. I'm not sure if I'm streaming it or not. We were talking about it, but it hasn't gotten to that point yet. So we'll find out. Hearing loss, Wolfie. Hearing loss.
Oh, the boy. Always the boy. So he didn't buy a parking pass for his high school this year. I got a call about it. He's like, I swear I did it. I said, just order another one.
Please be seated.
Now he's lost his registration. So now I need to go to Secretary of State to get him a new registration. So we can order.
We're back on the record after our evening recess. Good morning, ladies and
All
gentlemen.
for a parking pass at a high school.
I know, right?
I'd make
At
him
this
go get
point, as I mentioned at the close of yesterday afternoon, you've heard all the evidence and received the exhibits. It's now time for final arguments. But before you hear from the attorneys, I'm going to instruct you as to the law of this case. And where's Claire? Did she provide you 2 copies?
Where's Claire? We need Claire.
it. I don't think I like this judge.
She's been so vigilant and been with me all. Tish, can you see if you can find her?
Look at him. He just looks disappointed.
This judge.
Yeah.
He's just a good old born-grown judge from Iowa.
He seems like everything is just a bother to him.
I had we did mock summary arguments in when I was in law school, and we had to go out to this court in front of this real judge to do it. The court, I shit you not, was in the middle of a cornfield. Like we literally drove through the cornfield to get to it. And the judge is like this good old country judge sitting there. He's got his one clerk that's 1,000,000 years old, and
Been with him for 45 years.
yeah, and so we're getting ready to do our arguments, and the clerk comes in, and she's like, "Oh, Judge, we got Bobby," or something like that. It was like his name. And he was like, "Oh, okay, hang on one second, you guys." And he brings in Bobby. Bobby's wearing overalls and like a stained shirt. This is a big guy, and then he walks him in. He's like, "Bobby, what are you doing, man? We had
We're
this
off the record,
conversation
obviously,
like
with
last
Tish
week."
out of the room.
I don't know what the
It seems
details
every
are. He's
time
like,
there's some hiccups that you need to deal with.
He was the one regular at the
Claire, you
jail.
have those.
yeah.
That one guy that
Can you
always
at this
drinks too
point,
much and gets into a fight.
And
Yeah.
copies of the instructions to members of the jury. And members, ladies and gentlemen, I have 6 or 7 copies made, so you'll have to look on by 2s. Because how we have you seated, what
Uh-oh.
Uh-oh.
Baker.
Oh,
There we go.
oh. We're good. We're good. I think.
Audra's heading home from the courthouse.
Outstanding.
thank you, Ms. McDowell.
She's like, I'm
Ladies
so
and
stuck
gentlemen,
in traffic, I'm
I'm
just
about
turning around.
to read to you the instructions as to the law and the verdict forms in this case.
Well, it wasn't. That's
Members of the
sentencing
jury.
was not televised.
In this
and that was
case, the
unfortunate.
court gives
Yeah.
you the following instructions.
All right, I'm going to jump off, guys. Have
Instruction
fun.
number 1.
Later, buddy.
Trial information charges the defendant, Ivan Samuel Brammer, with the crimes.
Bo Bridges for sure. Bo Bridges for sure.
3, theft in the second degree. Count 1, murder in the second degree, includes the lesser crimes of voluntary manslaughter involuntary manslaughter, public offense, involuntary manslaughter, conduct likely to cause death or serious injury, assault causing serious injury, assault causing bodily injury.
And for those that are
assault.
just joining or whatever,
Count
I think
2,
yesterday the state
abuse
and
of a
defense
corpse
rested.
does
So
not
today is
include
going to be
lesser crimes.
closing statements, jury
Count
instructions,
3,
and then verdict.
theft in the second degree includes the lesser crimes of theft in the third degree, theft in the fourth degree, and theft in the fifth degree.
I think we're not.
Instruction number 2.
I think we
The
decided
trial
that it
information
wasn't
is the
gonna be
document
worth
that
it.
formally charges the defendant with a crime and is merely the
We
method by
tried to do
which the
that with
defendant
the
is brought
Gretchen
into the
Whitmer
court for
case.
trial.
And since
It
the
is
verdict
not
had already
evidence.
happened, nobody seemed to really care.
Instruction number 3. Ivan Samuel Brammer has entered a plea of not guilty. The plea of not guilty is a complete denial of the charges and places the burden on the state to prove him guilty beyond a reasonable doubt. Whenever I instruct you, the state must prove something. It must be by evidence
However,
beyond
I
a
do
reasonable
think
doubt.
McKinley is going to finish
If the state does
hers.
not prove the defendant guilty beyond a reasonable doubt, your verdict must be not guilty.
Nikki, no, not
Instruction
this.
number 4.
I'm
Ivan Samuel Brammer is
Flux tonight,
presumed
I'm not
innocent
sure.
and not guilty. This presumption of innocence requires you to put aside all suspicion which might arise from the arrest, charge, or the present situation of the defendant. The presumption of innocence remains with the defendant throughout the trial unless the evidence establishes guilt beyond a reasonable doubt. Instruction number 5. You must determine the defendant's guilt or innocence from the evidence and the law in these instructions. You must consider all of these instructions together. No one instruction includes all of the applicable law. Instruction number 6. Nothing I have said or done during the trial was intended to give any opinion as to the facts, proof, or what your verdict should be. Instruction number 7. The duty of the jury is to determine if the defendant is guilty or not guilty. In the event of a guilty verdict, you have nothing to do with punishment. Instruction number 8. The defendant has been charged with 3 counts. This is just a method for bringing each of the charges to trial.
Only 3?
If you find the defendant guilty or not guilty on any one of the 3 counts, you are not to conclude the defendant is guilty or not guilty on the other counts. You must determine whether the defendant is guilty or not guilty separately on each count. Instruction 9. You shall base your verdict only upon the evidence in these instructions. Evidence is testimony in person or by deposition. Exhibits received by the court. You may examine exhibits closely, but be careful not to alter or destroy them. Stipulations, which are agreements between the attorneys. Facts may be proved by direct evidence, circumstantial evidence, or a combination of both. Sometimes during a trial, references are made to pretrial statements and reports, witness depositions, or other miscellaneous items. Only those things formally offered and received by the court are available to you during your deliberations. Documents or items read from or referred to, which were not offered and received into
He
evidence,
does kind of sound
are
like
not
Jeff
available
Bridges.
to you. The following are not evidence.
Like I could see the
Statements,
Big
arguments,
Lebowski.
questions, and comments by the lawyers. Objections and rulings on objections.
That's like your opinion, man.
Testimony I've told you to disregard. Anything you saw or heard about this case outside of the courtroom. Instruction number 10. In considering the evidence, make deductions and reach conclusions according to reason and common sense. Facts may be proved by direct evidence, circumstantial evidence, or both.
The rug really tied the room together.
Direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain of facts which show a defendant is guilty or not guilty. The law makes no distinction between direct evidence and circumstantial evidence. Give all the evidence the weight and value you think it is entitled to receive. Instruction number 11. Decide the facts from the evidence. Consider the evidence using your observations, common sense, and experience. Try to reconcile any conflicts in the evidence, but if you cannot, accept the evidence you find more believable. In determining the facts, you may have to decide what testimony you believe. You may believe all, part, or none of the witness testimony. There are many factors which you may consider in deciding what testimony to believe. For example, whether testimony is reasonable and consistent with other evidence which you believe, whether a witness has made an inconsistent statement, the witness's appearance, conduct, age, intelligence, memory, and knowledge of the facts, the witness's interest in the trial, their motive, candor, bias, and prejudice. Instruction number 12. Statements and questions by law enforcement officers and other investigators during interviews with the defendant are not evidence to be considered for their truth. The defendant's answers and responses to those questions and statements are evidence. Instruction number 13. Evidence has been offered to show Iwan Samuel Brammer made statements at an earlier time and place while not under oath. These statements are called admissions. You may consider an admission for any purpose. Instruction number 14. In this case, the defendant decided not to testify. The defendant is not required to testify, and no inference of guilt shall be drawn from that fact. The burden of proof remains upon the state to prove the guilt of the defendant. Instruction number 15. You've heard testimony from persons described as experts, persons who have become experts in a field because of their education and experience may give their opinion on matters in that field and the reasons for their opinion. Consider expert testimony just like any other testimony. You may accept it or reject it. You may give it as much weight as you think it deserves, considering the witness's education and experience, the reasons given for the opinion, and all the other evidence in the case.
I guess that makes sense for
instruction number 16.
Witnesses.
Yeah.
The burden is on the state to prove Iwan Samuel Brammer guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence or lack of evidence produced by the state. If, after a full and fair consideration of all the evidence, you are firmly convinced of the defendant's guilt, then you have no reasonable doubt, and you should find the defendant guilty.
Well, I was going to wait till Baker got back.
But if after a full and fair consideration of all the evidence or lack of evidence produced by the state,
We're fine.
you are not firmly convinced of the defendant's guilt,
I got to go, y'all.
then you have a reasonable doubt, and you should find the defendant not guilty.
Love you, brother. Appreciate you. Chat, you're always
Instruction
awesome.
number 17.
Like I said, Flux tonight at like 8:30.
When two or more alternative
stream.
theories are presented, or where two or more facts would produce the same result, the law does not require each juror to agree as to which theory or fact leads to his or her verdict. It is the verdict itself which must be unanimous, not the theory or facts upon which is based. Instruction number 18. To commit a crime, a person must intend to do an act which is against the law. While it's not necessary that a person knows the act is against the law, it is necessary that the person is aware he was doing the act and he did it voluntarily, not by mistake or accident. You may, but are not required to infer a person intends the natural results of his acts. Instruction number 19. A person is subject to prosecution in this state for an offense which the person commits within or outside the state by the person's own conduct or that of another for which the person is accountable if, 1, the offense is committed either wholly or partly within this state. 2, an offense may be committed partly within the state if conduct which is an element of the offense or a result which constitutes an element of the offense occurs within the state. If the body of a murder victim is found within the state, the death is presumed to have occurred within the state. Instruction number 20. A person participates in a crime beginning with the first act done toward the commission of the crime and ending when a person has been arrested or has escaped from pursuers. A person participates in a crime regardless if he is successful in committing it. Instruction number 21. Under count 1, the state must prove all of the following elements of murder in the second degree. 1. On or about the 13th day of February 2023, the defendant assaulted Ilene Gowan. 2. Ilene Gowan died as a result of being assaulted. 3. The defendant acted with malice aforethought. If the state has proved all of the elements, the defendant is guilty of murder in the second degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the second degree. And you will then consider the charge of voluntary manslaughter explained in instruction number 24. Instruction number 22. Murder in the second degree does not require a specific intent to kill another person. Instruction number 23. Malice is a state of mind which leads one to intentionally do a wrongful act to the injury of another out of actual hatred or with an evil or unlawful purpose. It may be established by evidence of actual hatred or by proof of a deliberate or fixed intent to do injury. It may be found from the acts and conduct of the defendant and the means used in doing the wrongful and injurious act. Malice requires only such deliberation that would make a person appreciate and understand the nature of the act and its consequences as distinguished from an act done in the heat of passion. Malice aforethought is a fixed purpose designed to do some physical harm to another which exists before the act is committed. It does not have to exist for any particular length of time. Instruction number 24. The state must prove all the following elements of voluntary manslaughter. 1. On or about the 13th day of February 2023, the defendant intentionally assaulted Ilene Gowan. 2. Ilene Gowan died as a result of being assaulted. 3. The assault was done solely by reason of sudden, violent, irresistible passion resulting from serious provocation.
Where's the proof?
If the state has proved all of the elements, the defendant is guilty of voluntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of voluntary manslaughter, and you will then consider the charge of involuntary manslaughter public offense explained in instruction number 26.
Wow, they have a lot of different.
Instruction number 25. A serious provocation is conduct that would cause a reasonable person to have a sudden, violent, and irresistible passion. Passion is not sudden, violent, and irresistible if there is an interval of time during which a reasonable person would, under the circumstances, have time to reflect and bring his passion under control and suppress the impulse to kill. Words alone, however abusive or insulting, cannot be serious provocation. Instruction number 26.
It's a short one, T-Ray.
The state must prove both of the following elements of involuntary manslaughter, public offense. 1. On or about the 13th day of February 2023, the defendant recklessly committed the crime of assault. 2. When the defendant committed the crime, the defendant unintentionally caused the death of Ilene Gowan. If the state has proved both the elements, the defendant is guilty of involuntary manslaughter, public offense. If the state has failed to prove either of the elements, the defendant is not guilty of involuntary.
Sorry, I had my cousin on the phone. It's been a long time.
Oh, I thought you fell in.
I don't have that much suction in my toilet. So everyone, I'm sorry, I'm back now, but I haven't talked to my cousin in half a year, something like that. So it was really nice. Yeah, and everyone go subscribe to Wheelhammer. He makes the magic sound.
Yeah, you should go over there and give him a like on this for sure.
Why so many different yet similar charges? This is like a congressional bill.
Yeah,
What is
mean, they have the initial charge, but they have a million lower ones. It keeps going down. Involuntary, voluntary, you know.
It's
If you don't
because
find him, yeah,
they
'cause they,
probably don't feel that that they have enough to prove murder one,
well,
and
they
then it's
don't,
better to put in the lesser included so they can fall on one of those as a compromise instead
well,
of
yeah,
just having murder one.
because they have all this speculation of this time between 10:26 and or 9:28 and 10:30 when she's on the Burger King camera, and apparently that's when she's dead skis.
Yeah.
That he did this thing, but they have, and then after that, they don't even see him on camera anymore, so they don't even know if they can't prove that he went and dumped the body.
No, just that his car was in the area. It's a she, and she doesn't. Yeah, well, she'll need what she probably wants what I make out of the marzipan. Unless the defense put up a stellar closing, I think the jury would take the state side for lack of defense presented. Yeah, they didn't put anything up for defense, right?
No, they didn't do anything, no.
No. So.
And then for the fact that they don't even know the cause of death, that's a big one for me too.
Yeah, I would probably have tried and do something about that. I love Valhalla right back, but when your family calls, you have to answer the phone, even if you're kind of my family as well.
Mm-hmm.
Well, at least lesser child is included in this one, so my guess, without knowing, he'll end up convicted. I'm not. I think he could go for murder one, just because they have no. But again, if you have one or two holdouts, it's really easy to land on a compromise. We saw that in Kara.
Well, like, I mean, like me and Dave agree that the fact
manslaughter, public offense, and you will then consider the charge of
You agree?
involuntary manslaughter.
I thought that he was done just talking crappy crap, so I thought I'll start it. But you and Dave agreed.
No, because we were saying that the people probably will look at the fact that his story changed so much when he was with the police the 3 different times. But it isn't real. Like Dave's right. We were talking about that. It's not that his story changed. It's that he was just remembering different things. And that's not necessarily changing your story. That's just like, hey, maybe, oh yeah, I remember doing this. But but people could take that as it looking bad. So I think that's what we'll probably do him in.
Yeah, exactly. Because the second I forgot. We saw that in the Lorianne as well. They really harbored on, she changed her statement. No, she said, I don't clearly remember it. Oh, I remember this, and then put it in the testimony.
Yeah.
We're just about. I just had
Conduct likely to cause death or serious injury explained
Looks like
in
he's
instruction
still
number 27. Instruction number 27. The state must prove all of the following elements of the crime of involuntary manslaughter. Conduct likely to cause death or serious injury. 1. On or about the 13th day of February 2023, the defendant recklessly assaulted Ilene Gowan. 2. The defendant did the act in a manner likely to cause death or serious injury. 3. By doing the act, the defendant unintentionally caused the death of Ilene Gowan. If the state has proved all of the elements, the defendant is guilty of involuntary manslaughter, conduct likely to cause death or serious injury. If the state has failed to prove any one of the elements, the defendant is not guilty of involuntary manslaughter, conduct likely to cause death or serious injury, and you will then consider the charge of assault causing serious injury explained in instruction number 29. Instruction number 28. A person is reckless or acts recklessly when he willfully disregards the safety of persons or property. It is more than a lack of reasonable care which may cause unintentional injury. Recklessness is conduct which is consciously done with willful disregard of the consequences. For recklessness to exist, the act must be highly dangerous. In addition, the danger must be so obvious that the actor knows or should reasonably foresee that harm will more likely than not result from the act. Though recklessness is willful, it is not intentional in the sense that harm is intended to result. Instruction number 29. The state must prove all the following elements of assault causing serious injury. On or about the 13th day of February 2023, the defendant did an act which was intended to cause pain or injury or result in physical contact which was insulting or offensive or placed Iwan Gowan in fear of immediate physical contact, which would have been painful, injurious, insulting, or offensive to her. 2. The defendant had the apparent ability to do the act. 3. The defendant caused a serious injury to Iwan Gowan. If the state has proved all the elements, the defendant is guilty of assault causing serious injury. If the state has failed to prove any one of the elements, the defendant is not guilty of assault causing serious injury, and you will then consider the charge of assault causing bodily injury explained in instruction number 30. Instruction number 30. The state must prove all the following elements of assault causing bodily injury. On or about the 13th day of February 2023, the defendant did an act which was intended to cause pain or injury or result in physical contact, which was insulting or offensive, or placed Iwan Gowan in fear of an immediate physical contact, which would have been painful, injurious, insulting, or offensive to her. 2. The defendant had the apparent ability to do the act. 3. The defendant caused bodily injury to Iwan Gowan. If the state has proved all the elements, the defendant is guilty of assault causing bodily injury. If the state has failed to prove any one of the elements, the defendant is not guilty of assault causing bodily injury, and you will then consider the charge of assault, as explained in instruction number 31. Instruction number 31. The state must prove both of the following elements of the crime of assault. 1. On or about the 13th day of February 2023, the defendant did an act which was intended to cause pain or injury or result in physical contact, which was insulting or offensive, or placed Iwan Gowan in fear of an immediate physical contact, which would have been painful, injurious, insulting, or offensive to her. 2. The defendant had the apparent ability to do the act. If the state has proved both of the elements, the defendant is guilty of assault. If the state has failed to prove either of the elements, the defendant is not guilty. Instruction number 32. A serious injury is a disabling mental illness or condition which cripples, incapacitates, weakens, or destroys a person's normal mental functions, or a bodily injury which creates a substantial risk of death, or which causes...
Yeah, it's kind of fishing with a wide net. Every single charge, he can be convicted of saying hello to her that morning.
Did they throw the whole book in there? Jeez.
It was everything from murder one to jaywalking. It's
simple assault, yeah, to littering. If you think he littered.
Yeah, he littered with the one shoe he stole.
Yeah. That was so
Yeah.
funny. I heard that yesterday when he was like, we've proved that he stole one shoe. He stole the same. And I'm like, when? When did this happen?
No, don't think about it. Just convict.
Cause a serious permanent disfigurement or extended loss or impairment of the function of any bodily part or organ. Instruction number 33. The term bodily injury means physical pain, illness, or any impairment of physical condition. Instruction number 34. Apparent ability means a reasonable person in the defendant's position would expect the act to be completed under the existing facts and circumstances. Instruction number 35. Specific intent means not only being aware of doing an act and doing it voluntarily, but in addition doing it with a specific purpose in mind. Because determining the defendant's specific intent requires you to decide what he was thinking when an act was done, it is seldom capable of direct proof. Therefore, you should consider the facts and circumstances surrounding the act to determine the defendant's specific intent. You may, but are not required to, conclude a person intends the natural results of his acts. Instruction number 36. An assault is committed when a person does an act which is meant to cause pain or injury or result in physical contact which will be insulting or offensive, or place another person in fear of immediate physical contact which would be painful, injurious, insulting, or offensive to another person, when coupled with the apparent ability to do the act. Instruction number 37. Under count 2, the state must prove all of the following elements of abuse of a corpse. 1. On or about the 13th day of February 2023, the defendant either A, hid or buried a human corpse, or B, failed to disclose the location of a human corpse. 2, the defendant hid, buried, or failed to disclose the known location of the human corpse with the intent to conceal a crime. If the state has proved both of the elements, the defendant is guilty of abuse of a corpse. If the state has failed to prove either of the elements, the defendant is not guilty of abuse of a corpse. Instruction number 38. Under count 3, the state must prove all the following elements of the crime of theft. 1. On or about the 13th day of February 2023, the defendant took possession or control of property belonging to another. 2. The defendant did so with the intent to deprive the other of the property. 3. The property at the time of the taking belonged to Eileen Gowan or Eileen Gowan's estate. If the state has proved all the elements, the defendant is guilty. You must then determine the degree of theft as explained in instruction number 39. If the state has failed to prove any of the elements, the defendant is not guilty. Instruction number 39. If you find the defendant guilty of theft, you should then determine the degree of theft. I've attached a question as part of the verdict form, which must be answered, and by so doing, you will determine the degree of theft. In answering the question, the state must prove the value of the property taken. You will check the blank next to the appropriate value on the verdict form. The following are the different degrees of theft. Property valued $300 or less is 5th degree theft. Property
Farm girl, no, I thought the charges was murder 1, $1,200, and what's the last one? Handling of a dead body. But all of a sudden, it's everything.
valued more than $300 but not more than $750 is 4th degree theft. Property valued more than $750 but not more than $1,500 is 3rd degree theft. Property valued more than $1,500 but not more than $10,000 is 2nd degree theft. Instruction number 40. During the trial, you've been allowed to take notes. You may take these with you to the jury room to use in your deliberations. Remember, these are notes and not evidence. Generally, they reflect the recollection or impressions of the evidence as viewed by the person taking them, and may be inaccurate or incomplete. Upon reaching a verdict, leave the notes in the jury room, and they will be destroyed. Instruction number 41. You may not communicate with any person outside the jury about this case before reaching your verdict. This includes cell phones, electronic media such as text messages, Facebook, Snapchat, LinkedIn, YouTube, Twitter, email, etc. Do not do any research or make any investigation about this case on your own. Do not visit or view any place discussed in this case. And do not use internet maps or Google Earth or any other program or device to search for or to view any place discussed in the testimony. Also, do not research any information about this case, the law, or the people involved, including the parties, the witnesses, the lawyers, or the judge. This includes using the internet to research events or people referenced in the trial. This case will be tried on evidence presented in the courtroom. If you conduct independent research, you'll be relying on matters not presented in court. The parties have a right to have this case decided on the evidence
I only had
they know
3
about,
last week.
and that has been introduced here in court. If you do some research or investigation or experiment that we do not know about, then your verdict may be influenced by inaccurate, incomplete, or misleading information that has not been tested by the trial process, including the oath to tell the truth and by cross-examination. All of the parties are entitled to a fair trial, rendered by an impartial jury, and you must conduct yourself so as to maintain the integrity of the trial process. If you decide a case based on information not presented in court, you will have denied the parties a fair trial in accordance with the rules of this state, and you will have done an injustice. Failure to follow these instructions may result in the case having to be retried and could result in you being held in contempt and punished. Instruction number 42. When you begin your deliberations, you should elect a foreperson. He or she shall see that your deliberations are carried on in an orderly manner, that the issues are fully and freely discussed, and that every juror is given an opportunity to express his or her views. In order to return a verdict, each juror must agree to it. Your verdict must be unanimous. It is your duty as jurors to consult with one another and reach an agreement if you can do so without compromising your individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with the other jurors. During your deliberations, do not hesitate to re-examine your view and change your opinion if convinced it is wrong. But do not change your opinion as to the weight of effect of the evidence.
I would just say if anyone was following the Armstrong case and want to go see the sentencing, Dave has gone live and will be covering it. So if you've been following and waiting for the coverage, go over there or and come back again later if you want to, or you can stay here and you can watch it later. Do whatever you want, but Dave is live with it right now. Yeah, he said the jury couldn't do a lot of stuff. I never heard it kind of like, "Oh, we're gonna be mad at you," but it's implied that you can't do the stuff.
Just because it is the opinion of the other jurors, or for the mere purpose of returning a verdict. Remember, you are the judges of the facts. Your sole duty is to find the truth and do justice. Instruction number 43. I'm giving you 12 forms of verdict. 8 forms of verdict for count 1, 2 forms of verdict for count 2, and 2 forms of verdict for count 3. You shall use only one of the forms of verdict for each count. When you have agreed unanimously upon one form of verdict for each of the 3 counts, and the foreperson has signed those 3 verdict forms, please notify the court attendant. Dated this 17th day of November 2023. You also have attached copies of the verdict forms. You know, count 1, verdict forms 1 through 8 cover 2 pages. Only one of those verdict forms will be used. And then on the 3rd page, you'll see count 2, 2 forms of verdict. One of those will be used. And finally, on count 3, there are 2 other forms of verdict. Only one of those will be used. Ladies and gentlemen, I've instructed you as to the law of this case. It's now time for summations, or what's often called final arguments from the attorneys. The state will have an opportunity to address you first, followed by an attorney from the defense, and then the state will have an opportunity for rebuttal. Their summations or final arguments will summarize the evidence, and they'll be recollecting evidence that you will later on in as part of your deliberation. They're not going to be trying to mislead you, but if your recollection of the evidence is different than theirs, you need to rely on your own recollection of the evidence. Again, their statements or summations are not evidence, they're arguments. But it's important that you give them your full attention, because their arguments are an effort by each party to present their position on each of these 3 counts. I'd ask you to give them your full attention. Mr. Forney?
Your Honor.
Counsel?
Oh, great. PowerPoint
Yeah.
with pictures.
Yeah, and no microphone, and the judge has his mic on still, so we can hear him pour water.
Oh, dude, come on.
Wilhammer, go buff something.
No, it's the stupid court.
Yeah, I know. Thank you, Wilhammer.
But what was different about it is that he said that if I didn't go into a bad news, or you've done that. The fact that there was no relationship. It didn't matter. It had been accepted. Did not have to go. In fact, I knew she wasn't drinking. She's not drinking. She had money that she earned, and she was working hard. And she was trying to find a place for herself.
We're back to the camera mic.
She trusted
Thank you so much,
even
Wilhammer.
though they were no longer seeing each other. She trusted the defendant
I shouldn't yell at you.
because they had known each other for a year and a half.
Thank you so much for what you're doing.
So that morning, on February 13th, 2023, excited enough, I'm sure, My job there. I have no idea what else. At some point, the defendant lost it. And tragically, Ilene lost her life. Now, Judge just went through all the instructions, and that was a lot. You guys will have the instructions. What I would like to do is just talk about a few of the instructions and highlight a few. First of all, in considering the evidence, you will make judgments, and you'll reach conclusions according to reason and common sense. Use your common sense. You all your experiences that you've had in you will be able to use your common sense in this case. Instruction number 16, I'm not going to read this. This is the state's burden. The state has the burden of proof to defendants. Guilt beyond a reasonable doubt. Here's the facts. You have the instruction. What that really means is in the state, if you're firmly convinced that we proved our case, murder in the second degree, then there's no reason for that. There's no reason for that. Instruction number 21. This is where we get into marketing instructions. And Mr. Wilbur talked to you about checklists. This is where you have to use the checklist. This is where you have to look at the elements of the crime. We have three different principles. The first, count one, statement prove all the following elements of murder in the second degree. On or about the 13th day of February 2023, the defendant assaulted Iwan County. State prove that. 33 injuries on her body. Iwan County died as a result of the assault. The defendant acted with malice of forethought. We'll get into malice of forethought. But here's the thing. If you believe Dr. Biden's that she was assaulted, that coat, grabbed, twisted up, and choked her. That's your question. It was held there.
Now they're going with that? Oh my God.
Yeah.
Those elements are wrong.
That's not what they said the first time around.
Mr. Boyd, I apologize for doing it. We have a full courtroom, and I think you keep the voice up. The media and so try to keep the voice a little louder. I want to make sure that as well as other folks in the document have the best hearing. I don't know. I don't know that. Thanks, friends. Thank you. I appreciate it.
I love old audio. Even with
Instruction number
Wilhelm's
22.
magic, it's
Murder in the second degree does not require specific intent to kill another person. Malice? What is malice? It's a state of mind which leads one to intentionally do a wrongful act to the injury of another out of actual hatred or with an evil
I love it
or
when they
unlawful
just
purpose.
reiterate what the judge had because
Assaulting?
they're not smart enough to just skip ahead in their statements.
That is a lot. Stop.
Yeah.
It's so annoying.
It may be found from the acts and conduct of the defendants. All
What's
the acts of the
the
defendant.
old saying? If you have the facts, beat the facts. If you don't have the facts, beat the law. If you don't have the law, beat the table. And this is what this guy's doing. Starting out with walls of text instead of giving you a quick rundown of what have happened and why he's guilty. I hate that kind of presentation.
Mhm.
We prove it in this case. And the means used in doing wrongful and injurious acts. 33 injuries. 33 injuries. Malice of forethought. This is not a first degree murder case. The state does not have to prove premeditation. Malice of forethought is a fixed purpose or designed to do some physical harm to another which exists before the act is committed. So it's not a reflexive. It's not something like a reflex. There's got to be a thought, but it doesn't have to be long. But if you believe the opinion of Dr. Bottom, that jacket was twisted up. She's been assaulted or is being assaulted.
I didn't say
All
that
the injuries.
before.
That coat's being twisted up.
No.
And it's being held there. And it's being held there for probably at least a minute. If you believe that, then you have malice aforethought.
If you believe that, you should be smacked over the head with a frying pan.
Instruction 37. This is abuse of a corpse. On or about the 13th day of February 2023, the defendant either hid or buried a human corpse or failed to disclose the known location of a human corpse. The defendant dumped Ilene's body in a ditch in a remote location where not likely to be found for a while. And at the same time, the entire time that law enforcement, friends, and family are searching for his body or her body, he is lying to law enforcement. He is not helping them find her. He's doing the exact opposite. He's throwing off the scent. He's making it more difficult to find Ilene.
More difficult?
Instruction number 38.
Don't think about it.
Statement with all the elements of the theft. From a theft standpoint,
Who's blowing their nose?
it's really going to be up to you what you decide the amount is. If we've met all the elements, you look at the amount. And the state believes that it's true in this case. The defendant took a safe. Safe has a value. $1,200 in the safe. Other contents in the safe. Purse is gone. Phone's gone. Is that more than $1,500, but not more than $10,000? If it is, and you are the ones that decide. If it is, that's theft in the second degree. If it's not, then you say it's, well, maybe I think it's more like 1,000. That's theft in the third degree. You are the ones that will have to make that decision based on the evidence that was presented. Instruction 19. I'm just going to highlight the last line. Last sentence. If the body of a murder victim is found within the state, the death is presumed to have occurred within the state. The body was found at 152nd and Mormon Bridge Road. That is Potawatomi County, Iowa. Instruction 13. Evidence has been offered to show the defendant made statements at an earlier time and place while not under oath. You saw interviews. You saw videos. You saw a video from February 15th with Sergeant Roberts and Detective Dyer. Roberts conducted the interview. You saw that interview. That's in evidence. You saw another interview from February 17th where Sergeant Roberts and Detective Brannigan interviewed the defendant. There were statements the defendant made there as well. You saw that. That's evidence. There were statements that the defendant made at the welfare check. When Officer Boldra did a welfare check with the defendant, and again, made statements, you have that evidence, that video. Now, you may consider any omission for any purpose, like credibility, right? So, in the first interview on February 15th with Sergeant Roberts, he says, I picked her up from Sherry's at 8:30. I took her to Mike Roberts' house. Then I went back to my apartment. Sometime later, I hear knocking on my window. I think it's her. February 17th, story changes. Sergeant Roberts followed up on that. And Sergeant Roberts figured out he didn't go straight to Mike Roberts' house. No, he must have taken a different route because the video evidence shows something different. Well, February 17th, story changes. Credibility, story changes. It's the mission of the defendant. Now, the defendant picks up Ilene, 8:30, leaves at 8:32. Doesn't go directly to Mike Roberts' house. Instead, once he does the corpse, Ilene had to pick up a safe. Then after we did all that, I took her back to Mike Roberts' house. Dropped her off, never saw her again. Oh, I get a knock on the window. I think it might be. Did get video evidence from Dudley Court, so now we know they actually did go to Dudley Court. And they also went to Sherwood Apartments to see if she could rent a place. Story number 3. At this time,
Yeah, but is it story
Hey,
number
Yamaha.
or is
Thanks
it?
for not ignoring us because I know you are trying to sweet talk Iris.
Hi, Yamaha. Because they did a lot of driving. Maybe he just didn't talk about the driving. It doesn't. I don't know. Anyways,
Yeah,
whatever.
is it something that you naturally thinks about the driving part, or yeah, it's I don't know.
I don't
I
know.
think it's kind of weird.
Well, it is weird, but it's also like the timeline that they actually found out he was doing. It really wasn't all that interesting. Like, it wasn't very memorable, I guess, you know.
Yeah,
Just a lot of driving and a couple places they stopped at.
but it's clearly the dry humping that's the most interesting in this case.
Yep.
witnesses have testified that now we know that the defendant's gone to Omaha. We know he's going that direction. And he's confronted about it. Did you go to Omaha? No, I don't remember Omaha. Then later, yes. Went to Omaha. Went to go get cigarettes. Went to Carter Lake, go around. Then I took her back. My brother's house. Dropped her off. Never saw her again. She came knocking on my window. Story changed again. Those admissions. Those you can consider that for any purpose in this case. Let's talk about some of the witnesses that did testify in court over this last week. Nicole Tippett. Nicole. She is the daughter of Ilene. Nicole last spoke with her mom at 8:06 a.m. while her mom was at shift.
Okay.
Her mom had just finished her clean shift. This is on February 13th, 2023. She always keeps in contact with her mom. She had great communication with her mom. And didn't have any communication with her later that day. And something wasn't right. Because that's not like her mom. On the 14th, she reports her missing. She said, I've got to go to law enforcement. We've got to report this. Report is made on February 14th. The defendant and Ilene also both lived with Nicole. So Nicole knows that relationship very well. I believe she talked about it being an off and on again. It was unhealthy, but she knew the relationship well.
She also said she did say they fought when they drank, but she also said they had a really good relationship when they weren't drinking. So
Exactly.
anyways, I just had to point that out.
Yeah, but they were fighting a lot when drunk. But that means they weren't fighting a lot when not drunk.
Yeah.
She also witnessed her mom accessing her safe. And that's important because she testifies about the safe, but she testifies about how her mom opened the safe. It's a key. It's not a combination, it's a key. She used the key to open up that safe, which is important detail. And she also talked about Ilene when she went to go purchase a diamond stud earring. That diamond stud earring was for the defendant. How about that? It's sitting there. There's the diamond stud earring. 17B.
And
We'll come back to another slide. But Justin Brammer. Justin Brammer is the son of the defendant.
She also
Justin
does
Brammer also
money
happens to be in a relationship.
She knows nothing about what was in the safe.
No, she knew what had been in the safe.
She knew there was a key to the safe, but she said she hadn't seen the safe since before Christmas.
Yeah, and she normally kept money, her social security card, and that's about it. But she didn't know how much money was in it.
I know.
With Nicole. So they lived together. Justin had some important testimony. He did talk about the fact that his dad told him the story about picking Ilene up from Sugars and driving straight to Mike Rothman's house. So that corroborates some of the evidence that you heard. He also talked about the defendant not dropping Ilene off in the driveway because some black hose was in the driveway. But what he also testified to was the fact that although he has his dad's tools and stores them, and now he considers them his, Justin, he never sold his dad's tools and never gave his dad money from selling those tools.
Okay.
225.
Always a cover.
The defendant takes that sentimental earring while Ilene is missing and pawns it
How do you know how he felt?
for
about it?
$160.
How do you know he even cared? To be honest with you.
Emily Brammer testified. Emily is the granddaughter of the defendant. The defendant and Ilene at one time lived with her at Cottonwood Apartments. The defendant and Ilene broke up. Ilene moved out. It was just the defendant and Emily in Cottonwood Apartments. So the defendant and his granddaughter are living at Cottonwood Apartments. She testified that when they broke up this time, it was fine. That was it. He was fine. She also testified that when Ilene was missing, she saw the defendant with Ilene's phone. And she described the phone with the pink case. And she further stated that she knew that phone because she had held that phone before in her hand. The defendant also told Emily, his own granddaughter, to lie to law enforcement if they asked her about crushing the trunk. She testified about some of the behavior of the defendant during the period that Ilene was missing. He was angrier. He drank more. He lost weight. He quit his job.
Jamie, I know you're too young to ever been in a relationship. Have you ever heard about after a breakup, people start drinking more, maybe not eating so much because they're kind of depressed?
Yeah.
You never heard about that before
Never.
after a breakup? Never.
I thought when you break up with somebody, you keep all of their stuff and you just hang on to it for your entire life because it's so important. I mean, I've seen my friends burn things.
Yeah.
I'm like, whoa.
My brother broke up with a lady when we were young, back when it didn't matter. And he was whining about it. I said, do what I do. You buy 2 6-packs and you drink them. And when you wake up tomorrow, you'll worry more about the hangover than the breakup.
Yeah. Like you always see those people that go through a breakup and then all of a sudden they're out partying every night because they're just trying to find something to do.
Yeah. I want to see a 600 pound butter cow as well, expert.
A butter cow? Like
Yeah.
what is a butter cow?
Ask the expert.
Actual butter cow, like butter. How do they keep it? Or do they make it
Ask
like
the expert. Don't ask me.
Is it like a new butter cow every year, or is it like the same one?
Ask Sauter. They have a big one in Ohio also. Hey, Lexi. And Danny is trying to turn herself into butter from the inside out. Ohio also have Cleveland. Hey, Farrell.
Hi, Farrell.
And she called in the welfare check because the defendant was making suicidal statements and she was concerned about her grandmother. Officer Boulder was the officer that went and did the welfare check. And you saw that video. What's interesting about that video, few things, but the most interesting thing about that video is the fact that the defendant talks about Ilene being raped on February 10th, which was the Friday before she went missing. And yet, his story is that on Monday, he went and dropped Ilene off at Mike Brockman's house, the supposed individual that raped her.
He talks on the phone. My name's Sarah. Yeah, I'm the last person to your life. I didn't say that. Yeah. I didn't say that. I said you were the last person that saw her before she went missing. So that's why it was important for us to talk to you.
You're always welcome to sleep with me, Farrell. You know that.
Megan Preston testified. Megan Preston is the owner of Sugars. Sugars is a restaurant bar that is 2.5 miles away from Mike Brockman's house. Sugars is the place where Bennett worked. Ilene worked there as well. And even Mike Brockman was a person that went there and drank sometimes. What Megan testified to was that Ilene came and worked her shift that morning, February 13th, 2023, and she did a good job. There was no issues with the shift. She had no observations of Ilene being anything wrong. She states that she's a reliable worker and she's a good communicator. There was a message, and this is in evidence, Exhibit 16, from approximately 2:44 p.m. Megan, who has Ilene in her phone as Ilene Cleanlady. Megan worked that shift and she was ready to go home. And Ilene was supposed to show up at 2 o'clock for a shift, but she never showed. So she's sending messages. She's trying to find where Ilene is because she needs Ilene to come in. At 2:20, she sends a text message to Ilene saying, "Where are you?" And the response back comes at 2:44, "I'm done, leave me alone." She testified that that's all. That is the response. Sam Brammer's communicated with Megan as well on Exhibit 16B. Again, Megan's trying to figure out where is Ilene. February 13th at 2:30, Megan sends a message to Sam Brammer, Facebook Messenger. You don't have to respond, but I was wondering if you knew where Ilene was. His response back, "No, ma'am." She texted me, sounds like she was drunk. Megan also provided video for us. She testified to that. She provided video that shows the defendant pulling up the Sugars and Ilene leaving with the defendant at 8:32 a.m. in the morning. She also provided video that shows Ilene walking in around 8:30 into the entrance of Sugars, and she appeared to be walking normal. She also provided video of Mike Brockman coming down later at night and dropping off Ilene's belongings, just like I testified to. Megan also testified about something that was a little odd, and that was that on 2/16, when the defendant was supposed to work his shift, that he was just sitting out in his truck in the parking lot, or in a vehicle in the parking lot, and he was supposed to be working his shift. And he never does come in and work the shift. Mike Brockman testified. Mike Brockman, straight shooter. He said he allowed her to stay a couple days. videos of Sugar corroborate his story. Everything that he said is corroborated. Dropped her off in the morning. She worked her cleaning shift. She was supposed to come back and pick her stuff up. She never did. Mike Rothman worked a full day work on 213. Worked a full day work on 214 as well. Mike Rothman was interviewed by law enforcement. His phone was dumped by law enforcement. And his appointment was verified. His boss, Marcia Delhoy, came in and testified to Mike Rothman working those 2 days. And moreover, she testified that when he would run to go get parts, that he would only be gone for 30, 40 minutes at a time. Mike Rothman had no relationship with Ilene. He was just helping her. Cheryl Martin is Mike Rothman's landlord. She lives 2.5 miles away from Sugar's out on Railroad Highway. She lives on a small little farm. She's got horse stables there. Mike Rothman rents the bottom space of her house. He has his own entrance in the back, like she testified to.
Farrell, this is the case of Iwan Sam Bremner. Did he unalive his former girlfriend and throw her in a ditch where she was found 12 days later, frozen to the ground, half eaten by animals? And did he steal $1,200 from her? The case itself was, well, we have a pretty good feeling he's going to get convicted, but we were promised a lot in the opening statements that we didn't see during the trial. And the state had 2 MEs testifying because the state's own ME couldn't find the cause of death. But then they hired someone else who clearly could see she was strangulated. GI prosecutor is talking way too much. Way too much. And it's all circumstantial.
Yeah, yeah.
He told her you can stay here for 2 days.
Yeah. She went there Saturday and he dropped her off on Monday morning and she was supposed to be out. She was supposed to come pick up her stuff and be out after work, so.
Yeah, and the defense claimed that or the defendant claimed that they had a sexual relationships where a lot of dry humping was involved.
Yeah.
So that was a weird relationship. But he said, no, I slept on the couch. I didn't want her there. That's why I drove all of her stuff down to Sugar's and threw it outside.
Yep.
Because I didn't want no trouble coming around.
Yep.
First of all, she had no idea about a black hose in the driveway. There was never a black hose in the driveway. And she also said that when strangers come to her property, her dogs bark. And she was there in the morning on February 13th, 2023. The defendant is saying that he's dropping Ilene off at Mike Rothman's house that morning. This evidence is to the contrary. Sergeant Roberts was the lead investigator in the missing persons case. It started off as a missing person. And he was the one that first spoke with the defendant. He was the one that was following up on the report that Nicole had made, my mom was missing. He interviews the defendant on 2/15, which is less than 2 days from when she goes missing. And when he interviews the defendant, there's a portion of that very beginning of that video where the defendant comes in and tries to say that the officer, Sergeant Roberts, said that he was the last person to see her alive.
That's right, he talked on the phone. My name's Ted Roberts. I'm sorry. I was the last person to see her alive. I didn't say that. I didn't say that. I said you're the last person that saw her before she went missing.
Last person to see her alive. It's been gone for 2 days.
That
The
couldn't
defendant
be.
is saying that because he knows
No.
he's already murdered her.
No.
No one else is talking about why after 2 days. Use your common sense. You don't think so? You don't. Someone's dead after 2 days.
You can't just. That's so stupid. That is stupid.
If you would, I just need to know what went on Monday morning. What happened Monday morning with you? Okay. And I know if I would come here, because one of her friends told me was supposed to come here and told me that I got. So did she tell you the friend's name? Okay, maybe she went to her names anyway. Half the people don't have to have her names, so I do. That's my brother me that I don't forget for, you know. And then, leaving the person back in the kitchen, I never came to know. Those are two that she was very, okay. So I got there, and I said, I'll be on that. She was gonna come inside. I don't want Megan to know that we're back, or you're with me. I said, okay. And, I go up, she was in the truck. We went out, right out to this. You know, that name, I don't know. Those are the one that trying to do something with it. And, drop her out there. Got left. And went too hard.
If Wilhammer can live clear the audio, why can't they?
That's what she texted me.
Oh my.
The night before Monday? Yeah, I'm sure she just saying that she did. I don't know.
What did even?
It says.
I couldn't.
What was
I
that?
understood something about giving some names and last one seen, and I didn't get anything else. But Jamie, have you missed something today?
What? Oh, is it haircut day? What is today? The 17th? Oh, did you get a haircut? It looks
Well,
so pretty.
you don't even notice me anymore.
So handsome. Look at you. Everybody.
We've grown too complacent in our relationship.
He dropped her off at my car. Goes back to his apartment. And then he receives a text. Text from my Ilene somewhere else. That's at his phone. Sergeant Roberts followed up and realized that this isn't end. This interview was trying to corroborate his story, and videos aren't corroborating the story. Detective Dyer, he was part of this interview. Detective Dyer, I don't recall him asking a single question, but he was there. But Detective Dyer came in and testified. Detective Dyer went and picked up the defendant and brought him to the station to do the interview on February 15th, clip that you just saw. And after the interview was over, Detective Dyer takes the defendant back to Cottonwood, back to his place, where he lives, his apartment. And one thing that Detective Dyer notices that caused attention is that the defendant, when he gets out, he walks directly over to the dumpster.
Good morning, Money G.
And just looks into it and then walks away.
Why? What?
When you start looking at some of the other evidence that you've seen in this trial, where you saw the video of the defendant coming back from Trainer, going straight to his apartment on February 13th, arrives around 1 o'clock, gets out of his truck, starts taking stuff over to the dumpster, putting stuff in the dumpster.
You know how many times you?
Thank you, Iris, for noticing. Only 2 hours into a stream. But thank you so much for the super chat.
First of all, you're on a baby screen for me, and you have headphones on.
Well, you can clearly see this is...
And you've been gone 90% of the time. So
Shots fired. Jamie has been with her other dad for too long.
No.
It happens in every relationship. It takes a few days to readjust to coming home. I want to stay with the other dad, fun dad. He gives me happy meals.
He didn't give me shit. I don't want to go over there ever again. I'm kidding.
No 2 Christmases.
You better make up for it during the holidays.
Well, still, thank you a bunch for the super chat, Irish. But I'm very short now.
Anyways, that is the dumbest argument I've ever heard in my life. Did you see him? He peeked in that dumpster. Guilty. You know how many times I stop somewhere and I see a trash can and I just go, you know what? I'm going to start cleaning out my truck because I let stuff build up.
Yeah, it's the DI. Well, my GI Joe do look like this. Oh, that's the wrong one. This one. That's me as a GI Joe. It was a different time. I had only one chin back then.
It's so ridiculous.
This is 2 days later. Defendants check and see if that stuff is still in the dumpster. Detective Ron Brannigan. We had a lot of testimony from Ron Brannigan. He ended up being the lead detective in this case. What Ron really did is he gave us the timeline. He tracked the defendant's truck, and we learned about the movements of the defendant with Ilene every Thursday. And pretty much through video, through intersection cameras, through private businesses, track the movements for the day, which also tell a different story than what the defendant had told law enforcement 3 different times. What we do know and what you have as evidence is that after leaving
Who's to say I haven't?
Sugar's at 8:32 a.m. with Ilene, and we have an exhibit where Eileen's in the truck and you can see her at 8:32 a.m. Law enforcement tracked the defendant's truck movements, and we know at approximately 9:28 a.m., instead of the defendant's vehicle going up to Mike Brockman's house, what we know is that after Dudley Courts, that this vehicle is heading towards Omaha. And this is at 9:28. So the vehicle's going westbound. And there's a gap there. There's about a 58-minute gap where we don't know. We don't know exactly. We don't have any surveillance. We don't know exactly where he's at in the vehicle. But Eileen's with him when he's going that direction. And we also know that from Dudley Court's videos, you see her walking through in the entrance up to her mom's apartment, down the hallway, back down the hallway again, and out of the building, and was alive and was walking just fine. You saw that with your own eyes in the video. And she was carrying a black safe. What we also know, and what you saw as evidence, is you saw the defendant's vehicle come back into Council Bluffs at 10:26 a.m. And we had some images where it appears it's Ilene in the passenger side, but those images were hard to get a lot of detail from, but you could tell that someone's in there. And what we also know is that at 10:30 a.m., the defendant goes through Burger King drive-thru. And you have a video.
When the dad jokes are that bad, we know
video.
that the closing argument isn't going
And we
well.
have a couple photos that are in evidence as well, and you can see that as well. And through the entire video, it's not a long clip, but it's long enough to see the defendant exchanging money with the individual working for Burger King. But when you focus on Ilene, she doesn't move. Not at all.
What?
And the only thing you can see moving in that video is two things.
Jamie,
What?
I know you never go to a drive-through because that will mean leaving your house. Have you ever sat in the passenger side of a car in the 1.5 minutes it takes to get your hamburger, maybe half a minute, and not been dancing erratically in the street?
I've been
Because I
asleep.
know every
I
time
wonder.
I'm at the drive-in, I'm
Yeah.
like this just to make sure everyone knows I'm alive.
Alive. Hey,
Yeah.
I've been asleep before when we went through a drive-through. I'm surprised people weren't like, "What's a dead lady over there?"
It's just, again, look at all of this. It's very suspicious. I watched the video multiple times, and he drives in. He's getting his stuff. Did they ask the drive-through guy? Did she look very unalive? Because remember, at this point, she should be beaten senseless and strangulated.
Well, yeah. I mean, I would think that when people have traumatic head injuries and bruises all over their body, then you would probably notice something was up.
Yeah, because she had
Well, and now
multiple.
that she's been strangulated with her coat, because they made that very clear now.
Yeah, after the witness. Yeah.
Yep.
Yeah. They, especially at night. It's, again, we're talking about a body that was severely beaten. It had contusions all over the face. But the guy in the drive-through is thinking, well, here's your hamburger. Oh, your lady looks like she had a rough night, and nothing else.
I know.
Yeah.
I don't.
Oh,
Yes, Farrell.
I just do it so I can use the carpool lanes.
He was smart enough to know that he needed to shut off his phone and all this stuff because they were saying all that. But he's not smart enough to know that he probably shouldn't go weekend at Bernie's and drive through a drive-through. Did he put some sunglasses on her? We're wondering.
And let's be reasonable. How many times have you unalived someone and thought cheeseburger right after?
Yeah, really hungry now.
Yeah, at least wait till because the smell could kind of ruin the hamburger.
I mean, unless you are so obviously sadistic and you get joy out of it, I doubt that you're going to have a massive appetite.
No, and yeah, there was a bed cover. You could just throw it out, her out back. It'll. Yeah, because you will have your last bowel movement.
Well,
Hey,
I know
Indigo.
the indigo.
Yep.
Yeah, because it's like, and obviously they're claiming it was like a heat of passion type thing where they got in an argument too, so you're all like mad and worked up. Like, I don't know. That's just me personally. I'm not ready to smash some Burger King after that.
Yeah, that's the first thing. Whenever we blow up on each other behind the scenes, I always say, Jamie, hang on. I know we're in the middle of an argument. Of course, you're right. I need to go to Burger King.
You need to go get some Taco Bell, right? Your
Yeah.
favorite.
Yeah. The only authentic Mexican cuisine. Yeah, it's ways. Yeah. Again, all of the sense. Well, there's always time for coffee, but he had something to eat. If he just went in for a flat white, no problem.
If people have found a way to do that with the distance, then we're getting.
Yeah. Well, I'm not the one to brag, but I could hit the East Coast on a good day. So, yeah. Ladies, well, if I flew to the East Coast and lay down on the sand.
What?
Defendant moving his arm out to exchange with the teller at the window, but you can see his.
In the lawyer's defense, no one remains dead still, no pun intended, for 2 minutes in the car. No, but again, on a shitty resolution, what can you see? And can you see if she's turning her head and talking? You can see her legs are staying still. But my
Yeah.
legs are still the most of the time I'm streaming. Well, and I'm moving around and a lot because I sit here for many hours. But for 2 minutes, I'll be sitting still. But I can still say, "Oh, you didn't pick me up in time." Well, I was late because I got hammered last night. Yeah, I gave you an engagement earring. I'm not going to talk to you anymore.
Mhm.
So
Well, that's
I could stay quiet for a little bit.
I mean, I agree with what Marco's saying, but also the video itself doesn't really show us much. I don't know if everybody's seen it, but all you see is like her kneecap leg. Like you don't see
Yeah.
her, and it's very.
Yeah, and remember where the when the airbag blows, your legs will not be on the dash; it will be around your ears.
Mm-hmm.
And not in a fun way.
Yeah.
Yeah, and Marco, that's my problem with this, is that they are saying this video shows she was clearly dead when he went through the drive-in.
Yeah.
You have to make the logical jump that, of course, you take a body through the drive-in to get a hamburger, then go dump her in a ditch, then go home again.
Yeah.
But also, it's very bad, and that's one of my gripes. Whenever we see surveillance videos, we have a party street in my town, and there's videos in each end of it. So if there's a fight there, they can use that. But the quality is less than, I don't know, if we pulled YouTube all the way down, you can't see clear faces clearly. You have to say, oh, he had that shirt on when he went around that corner. That's the guy who's hitting him. That's a problem.
Jesus Christ.
So yeah, they were streaming the Anderson Armstrong. So yeah.
Yeah, that's the whole thing, is like that video is they're saying, look, the detective said on the stand, because we were appalled by it, was she's clearly in an unnatural position and dead at this time.
Yeah.
Which is,
yeah, he needed his, but he didn't. He should have had another burger because he hadn't any energy. He just dumped her in a ditch.
he just pushed her out of the car into a ditch. She was buried by snow.
Yeah.
And his body pounding through his chest. You can see it in the video. He has already assaulted her. He doesn't know what to do with it.
Wait, what? What did he say?
And then, of course, we've got.
Did you say he's already assaulted her and he doesn't know what to do?
He has already assaulted her. He doesn't know what to do with it.
Yeah.
So he goes through Burger King drive-thru. Okay. Got it.
And then, of course, we've got the defendant eastbound heading out to Trainer, 14 miles away from Council Bluffs. And we know he's out there because we have video of it. Have him going out and have him coming back. Never in any of the stories of law enforcement going to Trainer. Not once. In fact, when he's confronted about it, didn't have an explanation for it. His story was conforming as law enforcement confronted the defendant about some of the other surveillance footages and knowing his location. His story kind of changes to conform with it. Like, for instance, I wasn't in Omaha. Well, we have you in Omaha. Okay, well, yeah, maybe I was in Omaha. 4/8 is getting cigarettes. Story conforms. When
It's a natural place to go hang out.
There was.
I had Burger King yesterday. It wasn't that great.
And then, of course,
do you have the same experience whenever you go to Burger King? You're always disappointed in what you get. She isn't listening.
Am I disappointed at Burger King? Is that what you're asking me?
Yeah, I always feel like you don't get. You're always thinking, oh, I haven't been to Burger King in a long time. I'll try it. And it's always a disappointment.
Yeah, there's much better out there. for sure.
Yeah, but we don't have much better. We have Carl's Jr., Burger King, McDonald's. That's kind of the staples. And we only have McDonald's in my town, so we get the exotic ones when we go out driving. And so yesterday when I was in Germany, I had a chicken royale, I think it's called, not sponsored. And I remember it as being pretty good, and it was just boring.
I will say I do like their chicken sandwiches, though. Their original chicken sandwich, the long one. That's always yummy.
Well, that's another thing. Burger King restaurants are always filthy. Well, I had pizza the other night because I had some nice people contributing to my pizza fund.
Shut up, Iris.
Yeah, she would. But remember, she'd rather have Five Guys.
Yeah, I would rather, actually.
Yeah, I got Carl's Jr. when I was in Odense the last time. That's good. I like Carl's Jr. Or Junior. And we get a veterans discount.
Arby's is my favorite of all. Like, I like Arby's.
I don't think I ever had Arby's.
Arby's is, a lot of people hate on them, but man, they're good. They're curly fries.
We don't, but again, we have 3 chains in Denmark: Burger King, McDonald's, and Carl's. So yeah. Well, I used to be a baker. You don't want to know how the sausage is made. Just let us say that.
I told you that this was like years ago, but my friend worked at a Burger King and somebody got in trouble for jizzing in the mayonnaise. So not really wanting to go back to any Burger Kings ever in my life. Just kind of ruined it.
No, Jamie likes Five Guys. I never had it. 2 or 3 on a good night, but
it's really.
He comes back
Shut up.
to Cottonwood Apartments around 1 p.m. and he pulls into his normal parking spot. And we have a pretty lengthy video of the defendant dumping items into the dumpster and then just in his truck for several minutes.
Their roast beef at Arby's is delicious. And they have really good chicken sandwiches too.
oh, and they have wraps. That's Mexican. Crispy chicken club wrap and crispy buffalo chicken wrap. That sounds Mexican.
Aw, Food Fairy, you're the sweetest. Look at her. She's always coming.
Someone notices when I get a haircut.
You got a haircut today, did you notice? Or did you just love his hair in general?
I'm sharp. Is it his truck? What are we watching?
This is when he finally gets back. Oh, wait. Where are we at? Never mind. I'm trying to... I have it all written down because their videos were stupid. That's supposed to be them showing him coming... See, he's dumping stuff in the trash can. That's what they're saying.
Oh, that's in the top corner where we couldn't see anything.
Yeah.
Turn it back. It's got an item in it. And it's safe. He's walking over to the dumpster. And he dumps it in the dumpster. And then he walks back with what? A bag. Got rid of it. Your bag was gone. Officer Wright. He testified that he was the one that pursued the defendant on February 21st.
Half-pound roast beef.
When the defendant was with law enforcement.
It's just half a pound of roast beef between 2 buns.
Eventually, the defendant was arrested on February 24th. But importantly, the truck. You got to see video of the truck.
Yeah, that's where you can buy the
You got
good
to see
weed.
a vehicle that appears to be running just fine. Didn't see any smoke coming out of it. In fact, the vehicle was running well enough that law enforcement didn't keep up with it.
Half a pound of roast beef. Oh my god.
Yeah, smothered in Arby's sauce.
Come back to that.
Delicious.
Sergeant James Doty. Sergeant James Doty testified that
I have
reported maybe $1,200 in Iwan's life
the
savings.
U.S.
He also interviewed the defendant, and the defendant admitted that there was
get
between
freedom.
$600 and $700 in the safe.
and Texas.
Sergeant Doty also followed up on the bank deposit. And 2 days after her disappearance, a $1,200 cash deposit went into his bank. You saw the video. You saw the evidence of it. There's a deposit slip for it. $215, $1,200.
You have so many.
Defendant told law enforcement that he sold some tools on Facebook. You already heard from Justin. He didn't sell any tools for his father on Facebook. He didn't sell any tools for his father and give him any money. Going back to the truck, Sergeant Doty also verified that the truck was in fact crushed, lakeside recycling. Interestingly enough, when the defendant was arrested on February 24th, law enforcement, they did a little walk around the truck just to see if there was anything damaged in the truck. The officer testified they didn't go get DNA. They didn't try to find any blood or anything. They were just looking to see if there was some kind of altercation in the truck. Appeared to be normal. They didn't do anything else with it. Defendant gets arrested, goes to jail, bonds out the next day. And what does he do? He goes and crushes his truck. A truck that appeared to be running fine in the video that you saw, and he crushed it for $750. Remember how I said use common sense? $750 to crush this truck for. And wants to make sure that the truck is closed. Sergeant Doty also, as he arrived on the scene when law enforcement found the body, or when law enforcement came to the scene, the body was found on February 26th. Sergeant Doty was also the one that was able to verify that those are the clothes that this body appeared to be the same clothes as Ilene when she went missing on February 13th, 2020. So he was able to connect the missing persons case to the deceased body that was laying in a ditch 2 weeks later out at 152nd and Old Norman Bridge. Deputy Zach Norman, he was first on the scene, and he secured the scene. He's the one that called Sergeant Doty, and he testified as to his observations of the body, and his observation was there was some kind of feature mark on her neck. CSI Hadley Kaba. She came out and took pictures of the deceased body. She also took pictures of the area, and this was in fact an area where a lot of people do dump and crash to remote location.
Well, it could be blood all over the car.
You heard testimony from Special Agent Nathan Howell. He was the FBI individual that presented the cast report. And there was a lot of information on that, a lot of technical information. But what we can...
Well, I was already
is that
limited, so...
Both phones were together on February 13th. They were traveling together as well. And we would expect to see that in the morning because we know from the evidence that the defendant is traveling. We know the defendant picks up Ilene and they're traveling together. And we know his direction at this point. So we expect to see the phones at that point. But what we also learned is that the phones are together and traveling together when they're not supposed to be together. Remember the evidence. The defendant says he dropped her off at Mike Brockman's. He goes to his apartment. At some point, she texts him, Why are the phones together the entire time? Because he has her phone and they're traveling together. And this evidence shows that. Interestingly enough, both phones go off network at the same time when they go to Trainer. So her phone is with his phone when they go to Trainer, which is 14 miles away from Castle Bluffs. And they're both, coincidentally, not able to communicate with the cell tower. Special Agent House said, well, all I do is deal with phone records. All I can say is that maybe they're roaming. Maybe it's airplane mode. Or maybe the phones are shut off manually. Detective Clark came in. He has different information. He doesn't have phone records, but he had the phone dump, the phone itself, the details from the phone. Because we got the phone information. And he did a distraction on that phone. And what we learned from his testimony is that when they're in Trainer, his phone is manually shut off and manually turned back on at the exact same times that the CAS report showed them going on the network in the CAS report. So now we know the answer for the defendant's phone. We don't have Eileen's phone. We don't have Eileen's phone. We're able to get her records from the provider, but we don't have her phone. But we have the defendant's phone. So we know at least the defendant's phone was manually shut off during that period that he went into Trainer and then came back to Trainer. Dr. Kelly Cruz. What did we learn? Good techniques. Good procedure. Good documentation. Good supplemental testing. It was a good autopsy. Dr. Cruz says the body just doesn't tell me enough. It doesn't tell me enough to support the conclusion of cause or manner of death.
She's going for 2
But she also
hours now.
testified that she's maybe only had 5 to 10 asphyxiation cases. Dr. Biden, on the other hand, he agrees with the mechanisms. They both agree on the mechanism. They both agree on the physical findings. But he believes the body tells a different story. He's done over 20,000 autopsies, and he's also done hundreds of asphyxiation cases. You have 2 opinions. There's actually 3 opinions, and it's the most important one. It's yours. Those 2 doctors, experts, don't have all the facts. You do. Count 1. We, the jury, find the defendant Ivan Samuel Brammer guilty of murder in the second degree, asking you to find him guilty. Count 2, asking you to find Ivan Samuel Brammer guilty of abuse of the corpse. And count 3, asking you to find the defendant guilty of that more than 1,500, but not more than 15 months. Thank you for
I think Vilhammer said it was doing that, by the way.
Yeah, it's. I don't think it's Wilhammer who's doing that. It's.
No, he said it goes robotic or something like that. It was a while ago.
But I just want to know: did they go break for lunch now, or did they just do a short break? Because they are at 11:30, and some days you had an early break, or
I don't know.
let me go check out the live feed to see if it's. Court is on a 20-minute break. Well, then it's not a lunch break. Oh, it was Wilhelm's audio that was screwed up. So, did the body have fabric marks on the neck or just a zipper mark on a side or sides? It had zipper marks on the right side, I believe it was. On out here. And they actually asked the first ME if there was any like rope burns or anything, and she said no.
No
That's
bruise.
why she couldn't.
No, there was just those, what they think are teeth marks from a zipper.
Yeah,
They-
and only that. But that's why the choking with a collar would kind of leave a pretty clear mark here, because it'll be the same as using a rope or something.
Well, that's what they explained, was that the soft side of the coat was on this side, and then the teeth were probably here, and then he pulled it tight. So, I mean, you
Yeah,
would have to.
but still, if you want to unalive someone, it's not enough that you just put pressure on a little piece of metal on the side of the neck, because you have arteries in both sides.
Mm-hmm. Yeah, but they explained it away because they said the soft part of the coat won't technically leave any markings, that it could just put the pressure on and not leave a mark. That was the whole thing.
She got new umbrellas last Friday.
Last Wednesday, yeah.
Yeah, that's what I said. Last Friday.
Yeah.
Exactly. You would still have, because in order to strangulate someone, you have to push hard enough that the arteries, which is not right under the skin, it's kind of like the body is made to protect all the major arteries. So you would have to put enough force to stop the blood from returning to the body, because you had the pinpoint bleeding in the eyes, which is consistent with a slow strangulation, because it's just that the blood goes up but can't come back down, and then you get the capillaries to break. So no other marks on the neck, but just a little bit of a indent here from a zipper. That doesn't sound reasonable in my eyes.
I mean, now they're saying he grabbed her coat and choked her out.
Yeah.
Now all of a sudden that's their theory. And then what? Just continued to beat her up? Where? When?
Yeah,
How?
but he kept saying yesterday it was consistent with a chokehold or a forearm to the neck. And then all of a sudden, oh well, it's the little thing on the side of the neck, so it must be the other one. Hey, Shelby Allen.
Hi, Shelby.
Yeah, it's pure fantasy to say that you can strangle someone and only leave a mark on the side of the neck. That's why in most strangulation where it's hands, you will see fingers on the side of the neck, because you have to put a little bit of pressure on. Well, I think they're fishing just to get a little bit of a conviction. That's why they threw everything in there, from jaywalking to murder one.
Yeah. Well, if you don't believe that he did this, no, it's
Yeah.
murder two, but still murder two.
Sorry, murder two. Yeah,
And then
because it wasn't premeditated, but still.
keep it down. If you can't
Yeah.
find out, yeah.
Well, to be honest, we are 56 people here. Show of hands, how many listened to all 2 hours and roughly 20 minutes of his closing arguments without checking newspapers, emails, Discord, Twitter, whatever. I even had a 20-minute phone call, and I still didn't listen in the end.
Yeah, it was just a lot.
Yeah, and the problem is, if it's a kink gone bad, even if you remember to say pineapple, it will still leave a little bit of red on your neck, because you have. It's not like I can just do this and then I'll die. You have to get on, because all the ligaments that runs in the neck protects you. We haven't seen Ivan, but the prosecutor smirked a lot. So okay, Farrell is real. Yeah, and no, and this is the problem with the whole unaliving by choking. We had the first ME said there was no ligament abrasions that she could see, but he could see it on the picture she had taken, clear as day. But again, he have done 500, she has only done 4 or 5, so she's not good at her job. But again, I bet you in 20 other cases, he has praised her as being the best ME on this side of Mississippi.
He did JFK's autopsy. I mean, he's the coolest man ever.
Yeah. The problem is he's really, 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 really old. Ligature. Yeah, that's an ointment. Or something. What do I know? I just know that she said there was no signs of choking that she could find. And she saw the fresh body. She did the autopsy. He just saw the pictures. I don't think he saw the body, did he?
Did he? Yeah.
I believe he said that he was watching some pictures and then had an opinion, and maybe he did another autopsy after that. But he saw the pictures and he could clearly see that there was abrasions.
Mm-hmm. I mean, that's really all he focused on, was the zipper marks on the one side of the neck. One side, by the way. One side.
No, with half his brain gone, it's a pretty easy autopsy. Well, you do still have to talk about all his many, many, many venereal diseases. I'm not sure that was in the public report. Yeah, he just reviewed her report and watched the pictures and could clearly tell she had been wrong about it. Well, they keep him. Yeah, he was big in his day. His time is over. If your school closed around the Second World War, you've been in the business too long. I think, did he testify that he had been a ME for 50 years or something like that? And
I think since like the 60s. So yeah.
Yeah. And to me, he comes off as an expert for hire.
Oh yeah.
And 2, you will get biases when you've been in the job for so long. And you won't listen to anyone else. If someone puts it in your head that, oh, it was clearly strangulation. Yeah, clearly. So, yeah, I didn't like his testimony. But again, what do I know? Oh, he was only helping at Lincoln's autopsy as part of his education. You have to think about that one.
Oh my God. There was a lot of things being said. It was funny.
Yeah. And to me, it's just weird with the two Emmys. It's yeah. Oh, you did an autopsy review at a conference with him years ago. He's a cool dude, but yeah. And the problem is, when you are the leading expert in autopsies, do you listen? It's kind of like what's her name, Doctor, the one whose son got high. Well, her son didn't get high. Her son drove her around, and she couldn't get in the stand. And what's her name?
Are you talking about from Letitia Stout?
Yeah.
Was it Dorothy?
Yeah. She had one note to play all the time. It was spousal abuse. Or what? No, it was TPI. Or what was?
No, she was a multiple personality. Wasn't it like multiple personality doctor?
Yeah, and
Dorothy Lewis. Yeah.
Yeah, she saw that in every single case because that's her thing. She knows that's the stick. That's why they pay her. And she only gets paid if she is going to testify. Well, she's clearly not guilty because she has multiple personalities. And yeah, it's I don't like when you have an expert for hire. That's to me it just comes off weird, especially if it's the state who hires an expert to disavow their expert.
Yeah, I mean that was weird.
Yeah.
Like this doesn't play to what we're trying to tell you guys, so we're gonna use this guy.
Well, we have a cougher.
I recognize your 5 W's, so that must be yours.
Yeah, but you want to go there on holiday, not when you're dead. Always.
Right? Oh my God.
I have been coughing for almost 4 weeks, and I do this. Why can't they do it in courtrooms?
Well,
yeah, he had an autopsy show as well. Yeah. You know there's always a cougher in the courtrooms.
You didn't miss anything. They were on break, so
Yeah, just had a 20-minute break. There's always a cougher. I think it's state mandatory.
see. Anybody have a chronic cough? Well, I need you in court today.
It's part of the ADA.
Yeah.
So everyone feels included.
Yeah, I do remember that. Every time you had a cough, you're like, uh-oh, everybody's...
Iris, what did you do?
I coughed in a store once during...
No, it's Iris. She's saying trial in February for me. Can we cover it? And how badly did you beat him?
Yep. No, I was talking about Indigo. Do y'all remember?
Yeah, I saw that.
You're scared to cough in public. I said, I did. You should have seen all the heads flipped around so fast. And I was like, ooh, this is fun.
I was at a store once after we had our restriction removed, and there was this guy walking around, of course, and then he started coughing, and he did this. Sir, you missed the point.
I would.
Irish, right. It's your clients.
Oh my God. It was fun. It was a good time for everyone.
Yeah, back in the good old days.
And I asked you to pay.
Wait.
Come on. Fast and easy. You didn't put on a defense, so just do a very good closing argument.
Let's do it.
We need lunch. It's
Now, I told you on Monday that the state was going to paint you or write you a story. And I asked you to pay attention to the main elements of the story, the 5 W's, as I call them. Who, what, where, why, and then how. The first thing that I wanted to start talking about was the jury instructions before I get into that. And each time we come back to my main slide, I have a snippet of the reasonable doubt instruction that you have, which is instruction number 16. That after a full and fair consideration of all the evidence in the case, or lack of evidence produced by the state, if you are not firmly convinced of the defendant's guilt, then you have a reasonable doubt and you should find the defendant not guilty. Now, Mr. Forney talks
they have a lot of lifting to do.
Some of the jury instructions, but I wanted to kind of highlight them from my end. So murder in the second degree, you've already read through these. Based upon state's case, I do not believe that, one, this happened on February 13th. That two, Ms. Gowan died as a result of being assaulted by the defendant. And three, that the defendant acted with malice aforethought. And if the state failed to prove any one of these elements, just one, if they fail to prove it, then you must find Sam Brammer not guilty of murder in the second degree. Mr. Forney also touched upon malice, instruction number 23, and you all have that, and you'll have that with you back in the jury room. I wanted to highlight for you all that it is an act done out of hatred or with an evil purpose. And this has to occur while committing the alleged crime of murder in the second degree. This has to be an act done with so much hatred and such an evil intent that you must find
Stop
Sam Brammer guilty of murder in the second degree. And ladies and gentlemen, they just don't have that. The second counts, instruction number 37, abuse of the corpse. Again, the defendant says, or the state says, on or about February 15th, that the defendant either hid or buried a human corpse or failed to disclose the known location of the corpse. And that he did so to the intent to conceal a crime. I submit to you, again, the state has not proved beyond a reasonable doubt that the defendant has satisfied either one of these elements. And again, we'll talk about that a little bit more throughout my closing. Count number 3, instruction number 38, is theft in the second degree, is what he's initially charged with, but you have also the lesser included of that. That the defendant took the property of another, and that he intended to criminally deprive him of that property. And again, I will submit to you throughout this closing that the state has not met their burden of proof to prove each element of this case, or each element of this count beyond a reasonable doubt. I have the snippet, which is the last paragraph of the reasonable doubt instruction on my home screen. It was the full one, and again, you all have it. But I want you to remember what we talked about during the jury selection. That a reasonable doubt is not all doubt, but it has to be of such a nature that you are firmly convinced that the state has proved their case beyond a reasonable doubt.
Well, how many have walked because the state was
Remember we
proved?
talked about the Tylenol
This
example.
guy should walk.
How if you'd be a little bit hesitant, you would not give that Tylenol to your family. So when you are considering all the elements under all these charges, you must be convinced beyond a reasonable doubt. And if you
We just caught up with the
are not permanent
live feed.
events,
That's why.
hesitate, then you have a reasonable doubt. And I want you to consider that this morning and well into the afternoon of your delivery. Mr. Forney showed you the verdict forms. The verdict forms I would like to highlight for you all are number 8, number 10, and number 12, which is finding Mr. Brammer not guilty on count 1, count 2, and count 3, respectively. So let's start with the first W. Who have we heard from this week? I have listed some of the key witnesses. We have Mike Brockman, Detective Brannigan, Sergeant Boldra, Sergeant Doty, Special Agent Hout, Dr. Cruz.
He loves this little PowerPoint. Look at all these bubbles.
Yeah, I would say, even if I was a good speaker, I would like a few demonstratives. But relying on PowerPoints, especially as the state did it, and if he's going to do the same, you have people reading what's on it, not listening to you. You have people listening to you, not looking at it, or you have people just zoning out because they have to pay attention to places. It won't work. That's why I don't even have my whiteboard here. So that's why I like to just use my whiteboard, write a few sentences on it, and talk about that, because some people are really good at learning if they see something they can hook it to. But using this seven bubbles next to the key witnesses, what does it mean? And he's probably going to make them move and everything because he took a PowerPoint class at high school. But it's just a waste of time.
Mm-hmm.
I did get my big boy haircut today. Thank you for noticing. Some people notice. Yeah. I like a good chart.
I like a good chart too. I like a good chart of what you're talking about. Just like really the key points. But they need to learn to tell a good story, because if you're not a good storyteller and you're not really passionate about the story you're telling, people don't give a shit.
No. And not to say anything about anyone, but that's why a lot of people like to watch streams with commentary, because most of the people who do this is kind of good at speaking. I'm not. I can barely talk. But you can get it explained in a way so you can understand it. You can ask a question. But if you're just here for another 2-hour and 20-minute lecture, as you had from the state, you will be sleeping by the end of it.
Mm-hmm.
No, he's probably the one who was always sitting in the background. Said, but could we do it in a PowerPoint?
And Dr. Bott.
An MG, yeah.
I'd like to start with
squiggly lines,
Mike
it
Brockman.
looked like
you all
a
are allowed to
biologist.
take notes throughout this trial, and you are allowed to refer to them back in the jury room. I was also taking notes, so I'd like to highlight one of the things that Mr. Brockman talked about. When he is working, he nearly always traveled alone to pick up those parts as a part of his job.
Stop it.
If he didn't bring back parts, it was rare, but it wasn't unheard of for his job to not bring back parts if he went into Council Plus to go back into Omaha and did not get whatever part he was getting.
Yeah, that could be good.
We have timestamps that you have received into evidence, but we don't have any specific clock out times. We just have the hour that he started working and the hour that he ended working. We don't know what he did that day.
Where's
and
Sel?
Marcia Delavoye
This is where babies come from.
Can't tell you exactly what he was doing back on the 13th, 14th, or 15th of February. She just can't tell you that, and neither can the state. The state made a lot of argument regarding that.
Witnesses.
The police talked to Mike Brockman that he had his story checked out. They didn't do a lot of the same things that they did with Sam Brammer. They didn't send his phone for a cast analysis. They sent Sam Brammer's phone, They sent Eileen Gowan's phone, but they did not send Mike Brockman's phone. And I think that kind of gets to the heart of the investigation in this case. The police zeroed in on Sam Brammer nearly from the beginning. And they didn't do a lot of the things that they should have done in order to prove up their case, to show you beyond a reasonable doubt.
Yep. Talk to the stupidest
That the
guy in the
person they're
room, and the
accusing of
smartest guy
crime
will understand you, not
actually
the other
did
way
that
around.
We also have some video of Mr. Brockman dropping off Ms. Gowan's belongings outside of Sugar's the evening of February 13th. He told her he could stay 2 days. She didn't show up at his house. So he just went and took her stuff and left it outside.
But I forget that I can change it.
Ms. Gowan's presumably only earthly possessions. She wasn't there. He didn't care. He went and left them outside the back of a bar. But he hid it behind a cooler, ladies and gentlemen, so that was okay. They were safe behind that cooler.
Yeah.
There was testimony not only from Mike, but from Carol that the house is always locked during the day. If Carol was out doing chores like she testified, then the house was locked. So there would have been no way for Eileen Gowan to actually go to that residence and pick up her belongings if the house was locked. That thought didn't cross Mike's mind. That thought didn't cross Carol's mind. So when she wasn't there, 2 days is up, I'm just going to go ahead and just drop her stuff off at the back of a bar. We heard a lot of testimony from Detective Brannigan, and I'm going to get into that here in a little bit. We heard testimony from Sergeant Boldra. Sergeant Boldra was the officer that was wearing the body cam during the welfare check of Sam Brammer on February 19th.
Yeah, and keep it consistent so everyone follows along.
Ladies and gentlemen,
and reach the natural conclusion of the
Sergeant
story.
Boldra voiced concern over Sam Brammer, but if you remember towards the end of the video, they really just wanted to talk to Sam Brammer again. They talked to him on the 15th, they talked to him on the 17th, they had him again on the 19th, and he was told, you are going to be committed whether you like it or not. Now you can go freely with us and we'll give you a ride, or you're coming with us, but he was going to be committed that night. And if you notice at the end of the video, Sergeant Boldra was making sure that Sergeant Roberts was aware that, hey, we have Brammer again if you want to go talk to him at the hospital. You also noticed in the video that while Sergeant Boldra was blocking up Mr. Brammer's truck before he took him to the hospital, that he had his flashlight, he was looking around inside, looking for a phone that Mr. Brammer was requesting. He testified he didn't see any blood. He didn't see anything out of the ordinary. Remember what Dr. Cruz said during her testimony. That the laceration on Eileen Gowan's scalp, the one that reached the outer table of her skull, didn't fracture her skull, but it left a little bit of a dent on her skull. That while it was on her head, it would have produced a lot of blood.
No, you missed. I made a demonstration where babies came from. You have to go back and see it.
I asked her, are we talking about a liter of blood, like the amount that a person would donate if they're donating blood to like the Red Cross? She didn't give us an exact amount, but she said a lot of blood.
You give half a liter.
And Sergeant Boldra had the opportunity to be inside that vehicle on the 19th. He didn't know one thing that was suspicious or wrong, including any blood.
You snooze, you lose.
Detective Fletcher.
That's why you have to stay on Baker.
Also had the opportunity to look inside the defendant's truck a couple of days later. He didn't notice anything such as blood or anything else in that truck. He didn't.
No, because they were doing a welfare check on him. And then he asked for his phone. He said, I'm going to get it for you. So he was helping him because he's a nice police officer. But again, why did he then crush his car if the officer saw absolutely no blood in it a few days before? Well, don't worry about it. Just convict.
Didn't notice anything suspicious. The thing is, in this case, they never asked Sam if they could actually go in his truck to look around. He cooperated. He gave 4, 5, 6 interviews. He gave him his phone to do an extraction. He repeatedly said in interviews, check my phone. I don't remember where I was, but you can check my phone and you'll know where I was. Law enforcement did not look inside that vehicle. And whether it was by consent or by some other method, if they wanted to, they surely could have.
I don't know.
Sergeant Jim Doty.
Jim Duggan?
I made sure to take some notes, and again, these are just my notes. You're reluctant to rely on your own recollection as to what was testified during trial. Sergeant Doty spoke with Sam Brammer around May 3rd of 2023. This was 2.5 months after Ilene had went missing and 2 months after her body was discovered. Detective Doty specifically testified that he had information that the safe contained $1,200. You have in your jury instructions that statements from officers during an interview with the defendant are not to be considered evidence. The only thing that we know about that safe is Detective Doty or Sergeant Doty stating, I have information. He didn't tell us who, he didn't tell us when, he didn't tell us where, he didn't tell us any of those things. The last time the state showed you testimony or evidence that someone actually saw what was in the safe was from Nicole Skipper, Christmas 2022, a couple of months before this. Again, Sergeant Doty talked to Sam Brammer on the phone 2.5 months after Ilene Gowan went missing. And the fact that Mr. Brammer stated, my son sold some tools for me on Facebook Marketplace. We don't know what time frame he was talking about. We don't know if it was in March. We don't know if it was in April. We don't know if it was in May. You're allowed to determine the credibility of a witness. Justin Brammer and Nicole Skipper, the daughter and son of each of the individuals respectively, are in a relationship together.
Yeah.
So you are allowed to weigh credibility when determining these things, ladies and gentlemen.
Yeah.
I don't know how I feel about that.
Special Agent Hope. He had a pretty well-rehearsed testimony. He's obviously given that testimony before. He'd like to enlighten you all that they've helped exonerate 6 people, in the United States in the 13 years that the program's been around. So he told you that he can only interpret the data that he received. And the data that he received was from the historical cell site information provided by the service provider, in this case, T-Mobile. That's all I can do, and he didn't try to testify about anything else. And just as the state said a little bit ago, the cell phones were traveling together in accordance with the video evidence that morning. There's no doubt about that. You shouldn't have any problem with that. I don't have any problem with that. Mr. Brammer drops Ilene off in the area of Mike Brockman's residence around 11 a.m. on February 13th.
Sal can go back and learn finally where babies come from.
Just because Ilene's cell phone may have been left behind in the truck. An old 1999 Ford pickup does not mean that her or her deceased body was traveling in that truck. That is only the cell phone, and that is the only evidence that you have.
He's not wrong.
Nope.
Now the state is probably going to bring it up that if it was only her cell phone traveling with the truck, then how did she text Sam at 2:30, 3 o'clock that day?
Yeah, that's a good question.
Again, this is an old truck. We don't know if it was locked. We don't know if you could just open the door. You don't know if Ilene didn't flag down a ride on Railroad Highway. You notice in the New Horizons auto video, there's about 5 or 6 cars that pass in that 2 or 3 minutes that you're watching. It's not an unbusy road. So the fact that the state's going to tell you, there's no way she could have got a ride. She didn't have her cell phone. She couldn't have contacted anyone. It's definitely not outside of the realm of possibility that she could have flagged down a ride. Gotten into Sam's truck and got her phone. The state has to prove their case beyond a reasonable doubt. And you know that there are more than one possibility that it could be involved with that cell phone. Dr. Kelly Cruz, I will talk about a little bit more, but you heard what she had to say. She is an unbiased witness from Iowa State Medical Examiner's Office. She is obviously a younger doctor, but she's still a doctor. She's still board certified, the same board certification that Dr. Bodden has. Dr. Bodden was glowing in his review of her autopsy. Dr. Bodden said that he has rarely seen reports as good as hers, that he had no issues with Dr. Cruz's technique, that she went above and beyond. He said that she had excellent autopsy and procedure. He loved everything that she did right up until the point where it really mattered. And that was his conclusion. And the reason that he gave his conclusion or said that second opinions or second reviews are better than the original autopsy is because that second reviewer or person who takes a second look at it has more information than the original performer. You heard Dr. Bodden testify. He had police reports, same police reports Dr. Cruz had. He spoke to a member of Ms. Gowan's family, and he had her autopsy. Dr. Bodden didn't have anything more than Dr. Cruz had, and I submit to you, he had less than she had. So that brings us to Dr. Bodden, obviously a renowned and well-known pathologist, very good at testifying. He called his reporting handsome, which I think all of us got a good laugh about. But all that aside, he was not here to take this case pro bono or for free. He was paid $8,500 a day, which he testified was a reasonable amount of money for someone like him. He was paid $17,000 to render this opinion. And do you think that Dr. Bodden would have been brought in if he had the same opinion or agreed with Dr. Cruz's opinion? Going along with Dr. Cruz's opinion, Defense Exhibit 100, which is in evidence, is the quality assurance report form that was signed off on by Dr. Jonathan Thompson, the Deputy Medical Examiner for the state of Iowa. He's been doing this, I believe she testified for 15 years. He reviewed everything that she did. You can look at the form yourself. Didn't find one thing wrong, didn't disagree with it.
Yeah, got exhibit 100
So when we're
yesterday.
talking about second opinions and having someone else come in and review it, it wasn't just Dr. Cruz. She had her quality assurance report signed off. It's not just her conclusion that Dr. Bod is calling into question. He's calling into question the report as well. But we'll get into a little bit more about the pathologist later. Going along with some of the witnesses, and I think this is probably the best time to highlight some of the state's argument during their first portion. And that's something I'd also like to bring up, is this is the last time I'm going to be able to talk to you guys. After I sit down, Mr. Wilbur is going to have the opportunity to stand up and give you some more arguments. I don't get another chance after Mr. Wilbur to come up and argue against the points that he makes. So when Mr. Wilbur is up here speaking to you all, I would really appreciate it if you could maybe think about how would the defense attorney respond to that? How would Mr. Munger respond to the point that Mr. Wilbur is making? Because I won't have the opportunity to get up here and tell you the points that I disagree with Mr. Wilbur. So I just wanted to point that out before getting into that.
He
But
should be
responding
smart enough to
the
respond
state's
to it
arguments
before
about
they
some of
come
the
up.
other witnesses.
He's not doing a great job.
There were some inconsistencies. So we have Justin Brammer said that Nicole reported Ilene missing on 2/13 at 9 p.m. If you recall, Sergeant Roberts said he didn't get a report until the 15th. We had Megan Preston and the text messages that were received in the evidence. She didn't respond to the text message questioning the identity of the person during that text message. If you look at it, it says something to the effect of very grown up, very responsible. But now that doesn't sound like Ilene. Not in the moments, not when she was actually communicating, but later.
Yeah, Irish. It's not that he shouldn't say that they will have the last word, but he should kind of say when they get back up here, they will say this, they will say that, they will do this, they will do that. If try to preempt their arguments, but he just seemed deflated to me.
Mm-hmm. Yeah, that sucks.
There's been a lot of
Yeah, he's not that good.
Not that compelling.
No, and he needs to spruce it up a bit.
talk of this diamond stud hearing as well. It is uncontroverted. There's no question that Mr. Brammer was arrested on February 24th for eluding, and he had a $500 cash bond on his account.
He's a lawyer.
a
He
total
should
of
lie
$1,000.
better.
He was bonded out for $1,000. So what do you do when you owe someone some money? Not just someone, your granddaughter who bonded you out. You try to pay her back. Best way you can. He was broken up with Ilene. Emily told you it was the final time they were not getting back together. So he had little items of value. He tried to make it right with his granddaughter, pay her back. Crushed his 1999 Ford pickup truck, which if you've ever been to an auto recycler, you don't get a haggle about the price of metal. The state's trying to tell you that this was just done in an opportunity to get rid of evidence that they had the opportunity to look at multiple times. Sam was trying to pay back his granddaughter. He was trying to come up with that $1,000 any way he could. The state has also made comments during their arguments about insinuating why would Sam drop off Ilene at her alleged rapist's house. You saw the video again, actually 2 more times. Sam said, I don't know if she's telling the truth or not. According to Nicole Skipper, it was a very unhealthy relationship. He doesn't know if she's telling the truth. He doesn't know what's going on. So the fact that the state is trying to argue to you that it makes no sense that Mr. Brammer would drop off Ilene at a rapist's house who had just raped him the night before, he didn't know. He does not know whether that's true or not. And he states that perfectly clear on video. The state talked about Detective Dyer seeing Mr. Brammer rummaging around in that dumpster after he dropped him off after that interview. I don't recall Detective Dyer testifying to anything of the sort, but I want you to look back at your notes and see exactly what he testified to. Again, those are your notes and your recollection. Speaking of the video that they brought up of Stan Brammer at his apartments, at the Cottonwood Apartments, state makes a lot of argument that he's now taking the safe out of his truck in a black bag and tossing it in a dumpster. You know what you don't see in that video? You don't see Sam running to and from the dumpster looking like he's extremely frazzled, like he just did something extremely worrisome. He's moseying back and forth. There are kids walking by. Elementary school just got out. There are cars going in and out of the parking lot. Don't you think that if he was destroying evidence, as the state said, that he might be trying to vigorously clean his truck instead of just moseying to the back, dropping something off, going back in, not in any real hurry, doesn't have cleaning supplies, doesn't have anything else. So these are just some examples of the state's argument that they're just arguing to you. They have to prove their case beyond a reasonable doubt. And that's something that you need to, again, consider. And I don't want to keep writing this horse, but you need to consider and hold the state to their burden of proof. That they must prove every element beyond a reasonable doubt. Talking about the eluding in the state's argument, that we don't see any smoke coming from that truck. There's no way that engine was blown. They also stopped the pursuit. We don't know what happened 4 blocks later. We don't know what happened 2 blocks later. We don't know. And again, they're trying to make this out that Sam was running from the cop, guilty conscience. He'd already been interviewed 3 or 4 times. He was stopped at a Walmart by the detectives. And they said, we want to talk to you. And he obviously didn't want to talk to them to a 4th or 5th time. So then they called the marked patrol car to light him up. I'm not saying that eluding is great or that he should have run from a marked patrol car. But he just didn't want to talk to the cops that day. Going to the what in this case. The investigation was led by Detective Rankin. He sat up here and testified for quite a long time. Now, again, in the jury instructions, you're allowed to consider the evidence, direct or circumstantial, but you're also allowed to consider lack of evidence. And I just wanted to highlight a few things that I believe the state's lacking in their investigation. No camera footage from Omaha. We tried. It was deleted. We couldn't get it. They tried, and they couldn't get it. If they would have tried when this was a missing persons case, back when they knew 14 days earlier, they could have got it. This is something that they could have got. The fact that they're saying, oh, it was deleted, it's not our fault. No, they could have gotten it weeks earlier, and they chose not to investigate that avenue. No follow-up with witnesses who saw Ilene on February 14th. Again, Sergeant Boldra sat up there and testified. He said he took a report from Caleb Moore, and that report was that Caleb Moore saw Ilene at a food pantry on 34th and Broadway on February 14th. We heard no testimony from Detective Brannigan that he followed up on that lead. We heard nothing else. Dr. Cruz sat up here and told you when she spoke with law enforcement, there are multiple reports that Ilene was seen on February 14th. Just like with Caleb Moore, we heard nothing about these reports about who had seen her, where they had seen her. We know when they said they saw her, which was February 14th, the day after the state was alleging this event occurred. We have no DNA evidence. You remember the autopsy photos? There were the bags on Ilene Gowan's hands. Both pathologists told you those bags were to preserve evidence. Dr. Cruz told you, I did fingernail clippings and I gave them to the proper law enforcement agency. You didn't hear anything else about any type of DNA testing that was or was not done. You heard both Dr. Cruz and Dr. Bodden state that strangulation, and not the neck compression that Dr. Bodden was talking about, but strangulation is a violent act, and it takes time. Dr. Cruz said it takes about 10 minutes. So when someone is strangling another person, that person is most likely going to be fighting, clawing, trying anything to stop themselves from being strangled. And you would think that during any of that fighting, she would have the DNA or some type of evidence on her hands of the person they were actually attacking. The state's going to try to tell you you can't claw someone when you're unconscious, but why would they take the fingernails and not run any tests just to make sure? Again, another lead that law enforcement did not follow up on this case. I've already touched upon the blood, no blood being found in Brammer's vehicle. Also, there's no blood on Exhibit 9, the coat that Ilene was discovered in. The state apparently has some theory that she was lying back and gravity caused the blood to go to the back of her head and not end up anywhere on her jacket or in the vehicle or anywhere else. If they're going to try to argue that this laceration occurred outside of the vehicle, she was in that vehicle. And according to them, she was unconscious and unmoving in that Burger King parking, or in that Burger King drive-thru. There would have been blood on that seat in the Burger King drive-thru if this blow had knocked her unconscious.
About an hour now.
Oh my God.
We also have
40
the
minutes
floss
only.
system that Detective Brannigan spoke
40
about.
minutes.
Detective Brannigan and Detective stated, we couldn't follow up on anything else because we were just relying solely on Sam Brammer's statements. We couldn't do anything else. You heard Detective Brannigan testify. I can put in a vehicle description. I can say, hey, it has aftermarket brush guards. It's got 0 taillights, as he said multiple times.
People
And that
don't
system
talk for
can
that
find
long
that
in my
vehicle
cases.
traveling by any camera in the county. He said, oh, sometimes we get, hundreds, maybe thousands of hits. But they know the suspect's vehicle. They know exactly what to put in that system to try to track this down at an earlier point in time. And they didn't do that. Burger King. It appears to be the state's theory, but they're going to come up here and tell you we have the alternative theories. If you don't believe one theory, but you believe another, you guys can all agree upon it. But the state is trying to tell you that Ilene Gowan was unconscious, unmoving in the vehicle at the Burger King drive-thru. That Sam Brammer was breathing, heaving, and just looking like he was about to pass out from exertion. You saw that video. You can see that video again. Look at the video. You can see Ilene's leg and maybe her arm, and the fact that her arm may be up on an armrest is an unnatural position. The fact that she's not moving is unnatural. She could have been asleep, but would it not have been nice to have heard from the Burger King employee who was in that video? He was kind of bopping around. He was having a good time at work. He wasn't screaming. Oh my goodness, there's a dead lady in my drive-thru. Oh my goodness, there's a lady who just got the crap beat out of her in my drive-thru. She's bleeding from her head. She's got bruises all over her face. She's got a tooth knocked out. No, we didn't hear any of that. I already talked about the fact that there's no historical cell phone analysis of Mike Brockman. And again, defensive wounds. There are going to be defensive wounds on a person that is strangling someone to death. A person is going to try to tell you that you passed out. They have no proof that you passed out or unconscious. There are going to be marks on someone, probably their arms, when they are trying to choke someone, because that person's not just going to roll over. And you heard Detective Brannigan state February 17th, I didn't see any marks. I didn't see anything that was a defensive wound on Mr. Brammer. So those are just some of the things I wanted to highlight that were missing in the investigation. But it's not an exhaustive list, ladies and gentlemen. And it's not Mr. Brammer's burden to prove to you that he did not commit this crime. It's the state's burden to prove to you beyond a reasonable doubt that he did.
Yeah, and he's doing what every other lawyer is. He's talking the beaten horse to death, and all of a sudden he has some good points, but no one's listening. He's been talking for so long, no one's listening. All of this could have been in 45 minutes, as I always say. Opening, closing, maximum 45 minutes. This is so bad.
So where did this alleged murder occur? We got Sugars. She's live at Sugars. We got Dudley Court. She's live at Dudley Court. Levi Carter Park. You all recall Special Agent Howe stating that they spent the two cell phones spent some time together at that park. And he specifically stated that was on the Nebraska side of Carter Lake. It wasn't on the Iowa side of Carter Lake. It was on the Nebraska side of Carter Lake. And that was directly before those two cell phones traveled to Burger King. They didn't take a circuitous route. You saw they went south and they went east. And it's of note that the art on Special Agent Howe's reports does include some of Broadway where that Burger King is located. I believe he was testifying that it was at Brammer's residence, but those arts, if you look at it, do include some of Broadway. We have the Brockton residence,
like that.
and we have.
That's what I said when he said, "Well, please remember what I might have said because I don't get the last word." Put in some humor, put in some fun there, but end your statement with that, saying, "And now the state will stand up and rebuttal everything I just said." And well, while they do that, think about this, and this. Because they have the last word, and and just make some jokes. I can't really make some up right on the spot because he's been talking for so long. But the problem is, lawyers like to talk, but they're just not good at it. Well, if you don't have the case, you don't have the evidence, you don't have the law, then you have to talk.
Trainer and Old Mormon Bridge Road. I don't know if you all recall, Detective Brannigan stated in that interview on 2/17, and let me pull my notes so I can tell you what I have down. Detective Brannigan said, "You forget things, you know. I believe that people do forget things. I understand if I were to ask my co-counsel, Mr. Reedy, hey, what did you have for lunch on Tuesday? I would be willing to bet that he does not remember what he had for lunch on Tuesday. It's not something that is misleading. When brought to his attention, Mr. Brammer gave them more information. He repeatedly stated, oh no, there's no way that I went to Omaha. But he's saying, check my cell phone. He just didn't believe that he actually went to Omaha on Monday. He thought he might have went on Sunday. He did not believe that he went on Monday. But obviously he did go on Monday.
There's a silver lining in every cloud.
The state is trying to argue that he never talked about this trip trainer, how it's so relevant that he never
he's
talked
making
about
good
this
points,
trainer.
but he's making too few and too far between. And he's talking to the jury to sleep before he made them.
Sam, 62 years old, he obviously drives around a lot. You saw the historical analysis. He just drives around a lot. And the fact that he went out to trainer and there's nothing of it should be of no value to you all. But again, you're the trier of facts, and you are to determine what weight to get out of this. Old Mormon Bridge Road. Old Mormon Bridge Road. You again remember Special Agent Howe's historical cell phone analysis. Not one single time was Sam Brammer's or Eileen Gowan's cell phone anywhere near what they deemed the crime scene on that report. Not one single time. State's gonna say, oh, then he must have left his cell phone behind. That's the only explanation. They had cell phone data from before the 13th until after Ms. Gowan's body was discovered. If at any time Sam Brammer would have made the trip up either to dump Eileen's body, or you know how they say that people go back to the scene of the crime a lot, to go back, see if anyone had maybe seen her body, the state would have told you that his phone was up there. It wasn't. They cannot place Sam Brammer at the scene of the crime. They say, oh, he turned his cell phone off for 58 minutes on the 13th. Well, I want you to remember, it was on for 21 hours after that. It didn't go anywhere. Again, I've talked a lot about the 14th, but I believe the state is trying to make the argument that there's possibly maybe some testimony. I know Hadley Kava talked about the changing weather conditions and the fact that Eileen was discovered with snow on one of her legs or ice on one of her legs, that it had to have been on the 13th because it snowed late in the evening on the 13th, 14th, 15th. We don't have any testimony that tells you exactly when it rained, when it snowed. This is all just people's recollections. They took down the reports. We don't know exactly. I think there's a little bit of testimony, but it was an unseasonably warm and cold February 2023. Temperature is changing a lot. If there's a shadow covering the lower half of Ms. Gowan's body, I'm sure that there would probably be some snow or ice left there, but we don't know. And they haven't, not only haven't they told us, they haven't proved to you that that was the case.
Boy, stop.
The state is trying to argue that Sam Brammer killed Eileen Gowan because he was jealous, that he no longer had control over her, and she had to go. We heard testimony that, yeah, they had some verbal arguments. There was no testimony that there was ever any physical assaultive behavior. People argue, no one's perfect, but we don't have any history of assaultive behavior. Sam Brammer was the one who asked Eileen to move out of his and Emily's apartment. It wasn't the other way around. If this was Eileen kicking Sam out of her apartment, I would argue, yeah, sure, he was mad as heck that he just was made homeless. But it's not the other way around, ladies and gentlemen. He asked her to leave. He said he was done with it. So the fact that the state is now trying to argue there's a jealous motivation behind all this, it just does not add up. It does not add up that after they break up, the state's trying to argue he pawned this sentimental diamond stud earring. They were broken up. You heard Sergeant Roberts state at one point to Mr. Brammer on one of the interviews, things are getting more dire by the day. People who go missing, they're
Yeah,
not heard from a little bit. It's not outside of the realm of possibility that they're gone. And that
but
can affect
their
someone,
clients
whether
must be
they were done
sleeping
with
as
the
well.
relationship or not. That can affect someone.
Yeah, you'll
Finally,
probably
I want to
be
talk
69
about
before
how,
he's
and again, this relates to Dr. Cruz and Dr. Bottom's testimony, respectively.
Yeah,
I'll start
this
with
is what
Dr.
he should
Cruz.
have been hammering all the time.
You have a report. You can go through her report as much as you want. You can rely on your notes. The main highlight is obviously manner of death. There are 5 manners. Or, I'm sorry. Yes, there are 5. I apologize. Manner of death, how she was killed. She doesn't know. Cause of death. Homicide, suicide, natural, accident, unknown. Those are the 5 options she has. She could have chose homicide if she believed there's enough evidence. She could have chose that someone killed Eileen Gap. She didn't. Dr. Thompson agreed with her as well. So when we talk about strangulation, we heard Dr. Bottom and the state talk about rear chokeholds, weak chokeholds, and then all of a sudden, oh, we're not talking about chokeholds anymore. We're talking about a coat being grabbed somehow, and by grabbing that coat and putting it around someone, you're going to occlude, meaning completely shut off the blood flow from the carotid artery and the jugular vein on both sides of the neck at the same time without affecting the windpipe. By closing a coat around someone's neck. I don't know if you all have kids and you put on the puppy winter coats. Think about what type of force that would take to choke someone with a collar of a coat. There's going to be more evidence that a violent crime is occurring. You heard Dr. Cruz what she would expect to see in a case like this. Hemorrhaging of the soft tissue, bleeding of the soft tissue is what hemorrhaging is. She would expect to see broken cartilage, fractured larynx, fractured hyoid bone in the neck. She would expect to see petechia, which is the breaking of the blood vessels in the eyes, not only in the white of the eyes, but in the other part of your eye. She would expect to see bleeding of the face. She listed off 15 to 20 things.
That's actually a great way to do it. Maybe put up stuff like he just did. But why do they all of a sudden say it's a shirt strangling her? Why couldn't she find any evidence of it? But their expert from out of town could. The expert who cost $75, $7,500 an hour. That's a great way. I never thought about that. Make them answer the questions. I think opening and closing statements are kind of like music. You need to hit the first and the last note perfectly, because that's the notes that people remember. And again, how long is music today? How many of you sit down and listen to an opera? And how many of you are just listening to the 3 minutes and 20 seconds of a Taylor Swift song? There's a reason why TikTok is a thing. We lost the ability to enjoy long form content. So doing this old spiel and talking for hours, people is not able to listen for it. Yeah. Again, things he should have been talking about, but now he's been talking for close to an hour, and he's just getting to that one now.
Mm-hmm.
Yeah, 3 minutes 30 seconds on TikTok. Yeah, that and there's a reason they've figured out that that's really good for your brain, just to feed you small videos all the time, because then you just keep on scrolling. They keep getting the ad revenue, but you can learn something from that. Keep it short, keep it sweet, just like something else.
Things that she would expect to see. She thought 0.
Well, it's because I have something to distract you, and you can do your dishes, you can walk around, and then I don't talk for 7 hours. I have someone else talking for me.
Dr. Cruz told
stop.
you she does not prefer to put undetermined as a cause of death on a certificate. It doesn't give closure. It doesn't do a lot of things that most people would prefer when you have a medical examiner examining your body. But she chose it, and she stuck by her opinion. She said that she read Dr. Ballin's report. She disagreed with it. You, as the state said, are allowed to bring in your common sense and experience in this case. And not only are you allowed to do that, but the state has to prove to you beyond a reasonable doubt that this is what occurred. So taking your common sense and your everyday experience, wouldn't it make more sense for there to be evidence of injury when there's an actual strangulation rather than some mysterious puffy coat preventing any type of injury, but cutting off 2 arteries, one artery on each side, one vein on each side at the same time, without touching her windpipe, without breaking her larynx, without breaking her hyoid bone? You are allowed to bring in common sense. And one medical examiner from the state of Iowa said she doesn't know. She does not have enough information to determine. That was signed off on by her boss.
I had well, she wasn't a girlfriend. She was a potential girlfriend, and she took me to see.
So like I said, I will not have the opportunity to come back up here and speak to you after the school over.
I can't remember. I think
really
maybe it was
taking time out of your busy life. But this is a serious matter, and it deserves
what's the name
real
of it?
consideration. And when you go back in that jury room,
Well, it was some.
and you start your deliberations.
Oh my God! I understand why people made a
You have to
kerfuffle
be
when they had to
firmly
listen to that in
convinced
the 30s.
that Sam Brammer committed these crimes. Firmly convinced, beyond a reasonable doubt. And I submit to you that you should fill out on each count that he is not guilty.
Thank you, counsel.
Finally,
Ladies and gentlemen, I would like to move forward to plead on the argument. But if anyone needs a comfort break, I'm happy to take a 10-minute break. But looking, I think we're all ready to move forward. Statement, make your rebuttal, Ms. Wilmer.
Counsel.
I hate rebuttal.
All right, I know it's been a pretty long week for you. This will be the last that you have to hear from the lawyers. Then you get to use it.
Please,
I want to start with
let that be
sort
true.
of what, when, where, why, how. So this is rebuttal. It's my chance to rebut their argument. I'm just directing you. That's not a combination to my school locker. That's the jury instructions that I think you need to take a look at. 21, 37, and 38. That's murder in the second degree, use of a corpse, theft in the second degree. These are the jury instructions. There's no 8th grade essay, who, what, when, where, why, and how. I spoke about this jury selection. We have a checklist that we have to prove. It has the elements of the crimes. That's what we have to do. Now, obviously, it doesn't fall through, right? Who? The defendant, Ivan Samuel Brammer, right? What? The 3 charges. When? On or about February 13th. Where? Here in Iowa.
This is the third. You had one from the state, then the defense, and now this is rebuttal. It's not like yesterday where they had doing the Anderson case. There was tag teaming in and out. It was like the Royal Rumble in WWE.
At least some portion of it. That's the territorial jurisdiction instruction that you got. I'm not sure if I've got that listed. I feel like it might be 19. I'm right, 19, right? If an offense is committed wholly or in part in Iowa, then we have jurisdiction. So that's the where, right? Why? You don't always get to know the why. You can certainly guess, right? But that's not something we have to prove. We're not in the guessing games, right? How? Assaulted her, compressed her neck, hit her body, knew where she was, misdirected the police, took her stuff. I mean, that's where we're at. So that's we don't have any essays and we have to fill out anything along those lines. Follow the checklist. Follow the law. Another instruction I want you to take a look at is malice. When Mr. Munger was talking about it, he forgot sort of kind of an important couple of words there. He said you have to show actual hatred, evil. Then he moved on to talk about what evidence do you have of actual hatred or evil. Sort of missed the third portion of that instruction that says evil or an unlawful purpose. There's no suggestions here, there's no evidence here that Mr. Brammer hated Ilene Gowan. Don't know there's a lot of evidence that there's a lot of care there, but we're certainly not, it's not the state's theory that there's hatred. The question is, was there an unlawful purpose with regard to what he did? 33 blunt force impact sites. And if you believe Dr. Bodden's testimony that she died from neck compression, it would have taken a minute to do that. That shows you malice aforethought. That shows you the unlawful purpose. There's no lawful purpose to twisting up someone's jacket while you're assaulting and beating the hell out of them. Right? There's no lawful purpose for that. So malice.
But have you
if you believe that we've proven cause of death,
the
that's a whole separate discussion. But the malice is there. Mike Brock, possibly the worst defense scapegoat ever. Completely.
May we approach?
You may briefly.
Well, yeah, at least he's showing some fire, and if he can keep this short, he could win some points just by being
worst defense scapegoat ever. This is a gentleman that actually has a landlady that stays at his house that has barking dogs.
No, as long as there's no rope burns, I don't get the twisted jacket.
That keeps time.
I really thought that the defense should have hammered that one home.
To say random homeless person than to say person that works 50 hours a week and has a timesheet that shows that. They in fact tried to make the argument that he could have been gone for up to an hour. She said that would be very unusual, right? His trips were 30 to 40 minutes. Supposedly the theory is that it's reasonable for you to believe that Mike Brockman, somebody that allowed this lady, he's a good Samaritan, that allows not even a friend, really an acquaintance that he'd seen a few times at the bar. He allows her to crash at his place for a weekend. Depending, of course, once you believe that she's moved in with him one day after they've broken up. Right now, we've got somebody else involved. Right? This is just a gentleman that is just trying to be a good Samaritan and give her a place to stay. But you can see, I mean, it sort of sounded like Sam Elliott, what's for dinner, right? He's just super cowboy, low voice, straight shooter. That was the deal. She got to stay with me for 2 days. 2 days was up. She had to get her stuff.
What is that?
Show up. I left her a message. She got her stuff back. I mean, that's pretty much exactly the way it was.
Oh boy.
I mean, pick somebody that doesn't have like almost airtight alibi during this entire period of time. If you 12 people believe that it is reasonable that Mike Brockman is responsible for this on the 13th of February, I will submit to you that you're going to have a very early day. You're going to go back, you're going to let the foreperson, and you're going to let him, you're going to find him not guilty on all 3 counts in about 5 minutes. If you think that that is reasonable, that you have a pretty simple job for the rest of the day.
End it there. End it there.
So I feel like I got a little righteous indignation. A bit, right? I mean, who should the police be looking at? Seen on video, picking her up at 8:30. Gives a false story about what happened. Seen on video, she's walking down the hallway, perfectly fine with a black safe that they know has $1,200 in it. Coincidentally, a couple days later, he pops $1,200 cash into his bank account. Safe never shows up again, right? She ends up dead in the same clothes as when, I mean, who else of the 8 billion people on the earth should they be looking at? Obviously, we have to make sure we've eliminated everyone. But it's not a shock that that's the direction. He's given false statements. He's misdirected the police. He's been responsible for destruction of evidence. State's theory. I will admit the lack of blood on the coat is a little weird. Not going to pretend like that's not. But somebody bonked her on the head really hard, lacerating her scalp and taking a divot out of the top level of her skull. That absolutely happened. So whether it was the defendant or the mystery man, you're in the same boat. You're still stuck in the same boat. There would still be no blood on that coat. That is an issue that helps him. It does make it an interesting mystery for everyone to solve. So does the state have a theory? Certainly. I mean, if invited, state's theory is that there was some sort of assault, that her coat was twisted up, that she's down. It's pretty easy. You got somebody down, you're twisting up their coat, and you're beating the hell out of them with something 33 times. And during that, was there an intent
that was quite a weird way to
compress
say
that neck and kill? Maybe this is just an assault gone really bad. You've got an instruction that says murder in the second degree does not require specific intent to kill. This isn't a murder in the first degree. This isn't premeditated, meant to kill case.
But where is he supposed to have put her on the ground and beaten her
brutal assault
relentlessly?
That ended up with a tragic end to her life.
Well, I needed Jamie for
But
this
that's
because
still
she has
murder in
a
the second
time frame.
Bodley Cruz.
Where would the time be to beat her up after they left the monster apartment until they hit the Burger King? How long was
15 in
that?
parentheses, that's for my note. That's for you to pay attention to. Instruction 15, which is the one that talks about.
Yeah, it's kind of like reasonable doubt means if even the state starts guessing, there should be reasonable doubt.
Expert witness. You're supposed to pay attention to their training, their experience, and then decide, what you believe. The reality is, on the vast, vast majority of cases, Dr. Bodden and Dr. Cruz are of one mind. I mean, nobody's disputing how much the heart weighs or how much fatty tissue is in the liver. Nobody's having any disputes about any of this stuff. The contusions are where they are. They show what they show. Right? The difference is in the interpretation of those findings. Dr. Cruz is a well-trained, professional, fantastic forensic pathologist. But she's been doing this for 5 years. And she said she'd seen 5 to 10 asphyxiation homicides in her career. Dr. Cruz's relationship with death is still developing. Dr. Bodden has had a pretty close relationship with death for over 50 years. He's completed 20,000 autopsies, including handling hundreds of asphyxiation homicide cases. You can see his resume, his CV, Exhibit 14C.
I hate it as well, but
Please
we
read
have
that.
the burden
Please
of
read
proof,
the
so we
first
should have the
page.
last word.
The types of cases he's been called into, and this is not talking like, hey, back when I'm not even born, he's out doing things, which he was, right? This is him being brought in by Congress to do the assassination select committee to the for the deaths.
I believe that because of the way the wounds look, they were pre-mortem. But again, if she had a very severe head wound, we saw that in the Caroline Carla case. There was blood everywhere.
Mm-hmm.
How do they? The point I don't get, Jamie, you have the timeline. What time did they leave the mom's house and went to the Burger King? Because the assault has happened in that time.
Yeah, I said it was. They were at mom's house 8:45 to 8:51. She literally went in, got the thing, left, and then they went. And then they went to the Sherwood Apartments at 9:13. They were on camera, and then driving, and 10:30 was Burger King.
So he had about an hour to beat her within an inch of her life, or even unalive her. Somewhere from the Sherwood's apartments to the Burger King.
Yep, 9:20 would be like 9:20 to 10:30 would be the.
Yeah, that's 70 minutes.
Yep.
He's in the car at Burger King. She's beaten so severely, she has a dent in her skull, as far as I understood it.
Mm-hmm.
That is leaking like a sieve. He has no visible blood on him when he shops at Burger King. So he cleaned himself completely off. No problem in that. It happens. She has a gushing head wound sitting next to him at the Burger King drive-through. The dancing boy didn't see any blood in there. And they have a theory that the officers didn't see any blood because she was tilted backwards. To me, that's absolutely... Yeah, well, we know from the Caroline Carla case that they bleed a lot, because it's kind of like you have a lot of blood around your skull to get the heat away from it. That's why you lose, is it 2/3 of your body heat from your skull?
Yeah.
I've had a few nicks in my head. Yeah. It's
Everyone knows that. Because there's a lot of blood vessels in our head, like in your face.
Yeah.
Like that's why, like, if you nick your face, usually you bleed for a while.
Yeah. It's one of the worst places to get injured, because again, you have a lot of important stuff up here that you need a lot of blood for, and you need blood to get all the heat away. That's the way we kind of regulate our heat, and you need a lot of blood because this is our largest blood sucker, our brain, because it needs a lot of oxygen. So that absolutely makes no sense.
Yeah, that doctor was saying a lot of the stuff that you would think, oh, well, why wouldn't there be blood? He was like, oh, well, there's not really, like everything was like, oh, it's not always the case. It's not always the case.
Exactly, McBuffing.
I know.
And again, well, I always learned when I was in the military, when I watched a very important video, Cold Can Kill. It's an instruction video in how to not get hypothermia. you should cover your skull and you should cover your feet. But it was back, I'm 27 years old, so it's a few days ago.
Yeah.
Well,
my thing too is like, I don't even think we should have rebuttal, because it should just be one and then the other. Because if you have a good case, why do you need to go twice?
Yeah, and now he's talking about a whole new set of evidence that he didn't talk about before. So he can go and say all of this. There should be, you can only rebuttal what the defense said. You have your opening, they have their closing, and you can rebut what they said exactly if on a recross. You can't just start making up another story that they can't do anything about.
And you shouldn't have a worry if your case is airtight.
Yeah. Rob, I know I look 25, but I am 27. When I got punched in my nose, I bled like, I looked down and there was just blood everywhere. So no bleeding from the head. Yeah, right.
Of President Kennedy and Martin Luther King. This is him being brought in the 2000s to Poland to help them investigate the death of their president. This is him being brought in with Kobe Bryant's death here, fairly recent. This is him being brought in the very high-profile George Floyd case that America had to deal with about 3 years ago. I mean, he has been in the center. He is one of the world's most renowned forensic pathologists. And a family's quest for justice, they were not going to accept that one person could, with one opinion, say that their mom, that their sister, that their daughter got no chance to have her case heard in court. And so they went out and they found one of the world's best. And Mr. Munger is 100% correct. If Dr. Bodden would have come back with an opinion, sorry, folks, but I agree with Dr. Cruz, we might all still be sitting here today, but we wouldn't have a count one, right? We wouldn't be dealing with a murder of the second degree. Because if you've got no cause of death, that's sort of a tough case. Dr. Bodden has the experience. He has seen these cases, and she didn't just die for no apparent reason. I mean, I'm not sure if the defense is, we don't know. She just coincidentally died right after this brutal assault, just happened to die. He has given you the mechanism, and there's physical evidence to support it. We've got the abrasion on the neck that looks just like a zipper. And even Dr. Cruz says, looks just like a zipper. That's why she's getting into the neck, looking at all those internal structures. But she's thinking strangulation, just like the defense wants to try that case. They're like, this isn't a very good strangulation case. I'd like to defend that case, right? So that's why they keep talking about manual strangulation. But this is not a strangulation case. Dr. Cruz said it wasn't a strangulation case. Dr. Bodden says it's not a strangulation case.
This is a rebuttal.
Matt Wilbur,
hopefully you can take over soon for
this is not a strangulation
verdict.
case. You know what else we have crap evidence for? A gunshot death. We also have almost no evidence of a stabbing death, right? We have none of those. Why? Because that's not this case.
But you said it was.
She died because she got brutally assaulted.
Oh, you lying sack of shit. You were just going, your dude was
Let me just go and see if I turned orange.
Oh, sorry. You got all jacked
Well,
up.
I've been orange twice and got green again, so that's fine.
Your dude was just telling everybody how she got neck hugged by a dang coat for 20 minutes. And now you're like, this is not a strangulation case.
No, it's a magic unaliving case.
Yeah, the vessels in her neck got occluded enough that it took her life. The Exhibit 100, I just want to talk about the one exhibit that the defense put in.
Is that correct?
Yeah, okay. It's the quality assurance document. I mean, you should take a look at that because it's not like, it is literally like, was the subject adequately documented? Yes, it was. Were there enough pictures taken? Yes, there were. Was there adequate descriptions in the report? Yes, there were. The ultimate, she agrees, that he agrees, that it says, was the opinion consistent with the findings? I mean, it literally, as you go through all of that, I would bet had that document been reviewed line by line with Dr. Baden, he would have agreed with pretty much every line that was on it. She did do a fantastic job. She had accurate documentation. She had great photography. She had great technique. It's a question of, if you don't have the information in your brain that you can access,
at least this is a rebuttal from the state,
and if she's
so
had
hopefully
5 to 10
they'll be done
asphyxiation
before
homicides
midnight.
in her 5-year career so far. I mean, she talked to you about all the different methods of asphyxiation, the most common being strangulation, right? So if you're thinking strangulation, then that's what she's looking for. You got strangulation, you've got smothering, you've got drowning, you've got all these things. She said there's chemical asphyxiation you get. There's all these sorts of asphyxiation.
Drowning?
How many neck compression deaths has she handled in her career? Well, I mean, I submit to you less than 5 to 10 that are the total.
Oh.
As Mr. Forney said in his opening argument, right? Honestly, it's your opinion that counts. We have presented you with the evidence. You weigh it. You make the decision. This is not a place where one person or one doctor gets to say what happens with a case. We live in a system where 12 of you do. This isn't Matt Wilbur saying, do this. You get to make that decision. There are some unanswered questions in this case. Absolutely would like to have different things. Would like to have had somebody be able to examine Eileen's right eye. That would have been nice. Would have been nice to have the truck formally searched. I mean, are there...
Sue, you have missed 3 hours and 50 minutes of yapping. No, I'll be fair. 3 hours and 40 minutes. Within those 3 hours and 50 minutes, there were 10 minutes of okay stuff said. The rest is just annoying. Hey, Scott McGinnis, welcome.
Mechanisms to do that. He said by consent or otherwise. The otherwise, that's what we call in our line of work a search warrant. Sure, but they require all something else. It's called probable cause. You have to know a crime has been committed. And are they getting suspicious by later in February? You are right. They are getting suspicious. But the body isn't found until the 26th, and he is crushing the truck on the 25th.
Well, you've had 11.
Yeah, DOT evidence, the video. They said they only kept it so long, and then it gets overwritten. Again, that's a problem. I wish we had that extra, video. Why does the state not? Because somebody is playing, misdirection.
No, this guy is using Barton's opinion to rebut his own MEs. This is the state's rebuttal on closing.
Right? Somebody's playing the shell game, getting the police running around chasing their tail, trying to run down all of his various false statements. And so they get to look in here, and it takes days before they figure out that he's actually even gone into Omaha. Sergeant Doty, when Mr. Munger said that the statements of officers aren't evidence, that's when they're interviewing the defendant. So I just want to make that clear. That was a little bit of a tricky statement. When Sergeant Doty is testifying on the stand, and he said, we received evidence that there was $1,200 in that safe. And there's no objections. That's his testimony. What he says on the stand is evidence. When you're watching a video interview of the defendant, that's a different thing, right? Words that the defendant says are evidence, not questions and statements of law enforcement during that interview. During his interview with with Sergeant Doty, this defendant said he knew that there was $600 to $700 in that safe. The other evidence that the law enforcement had received was that there were $1,200. He doesn't know how much is in there. He just knows there's at least $600 to $700. What a coincidence that the information that law enforcement received, that there was $1,200, just happened to match up exactly with the amount that he's depositing 2 days after she's done this.
Yeah, that's convenient.
While he's not working. hasn't shown up for work. Right? Megan Preston testified, that she never saw him again after that physically. Remember, because she watches him hanging out in the back at the parking lot at some point in a vehicle. But sends the message like, hey, if you're just sitting out there, why don't you come on in? Never shows up. She hadn't seen him since the 13th. She had not seen him again until she saw him in court this week. Never showed up to work. But he's flush with cash. And remember, this is before the crushing of the truck. The perfectly functional. Nobody's suggesting that you should go haggle with the recycling dude for $775 versus $750. The point is, we have a legit running F-150 with some extra aftermarket stuff that's clearly worth more than $750, and he's crushing it for $750. Why do you do that? If you're in such a position that you don't have hardly any money in your life, why are you going to purposely get rid of a truck for way less than the market value? And the reason is, and he sticks around and he watches to make sure it's correct. Why don't you just walk in? If it's such a crap truck, why don't you just walk in and say, hey, give me my $750 and walk out? And he stuck around and waited to make sure.
Happy now?
What? Are you...
Point. Was it
I just turned down the audio. I didn't cut off the feed. It was just because Iris wanted it to stop. But, come on. What did you want to say?
No, that was just it. Like, he stuck around and waited and didn't just leave. So that's suspicious.
Everything is suspicious when it's in the court. Yeah, he got rid of the truck to get money. Yeah, that or because
and he should have sold it at market value because he was getting more. No, he wasn't. If his engine was blown, that's what he was saying. I mean, who knows if that's true, but that's what he told everybody.
Yeah, after he ran from the police, which is
you would be lucky to get. Who wants to deal with all that? We were just talking about that. Selling a car is not fun.
No.
Like selling a car, like on, putting it on Marketplace, and then you got to have somebody come and drive it and check it out. Sometimes they want to. I've had people want to take it to a place and get it looked at, and make sure and blah blah blah. And it's like, no, we're not doing all that. This is as is.
I have a scooter outside that I haven't sold. Put it on Marketplace, and then people start asking thousands of questions. I just pulled it off again. I don't want to. It runs. It's legal. You can pay me for it. Bye.
Yeah, you say as is, and then they're like, man, they don't like that because they want to, they want to make sure they're buying something quality. It's like, well,
yeah, well, with the price I ask for it, it's not quality, but it runs.
Yeah.
And again, do he need money here and now, or doesn't he care?
Value as potential evidence, and he wanted to make sure that went bye-bye. Cross-examination. You have instruction 41, one of the last instructions that you have. And it talks about why you should not be looking at things like Google and YouTube and all that other stuff, right? Because it says that is stuff that comes in outside the trial process. And part of that says that we don't want you to do that, and don't do that, right? Because you can be influenced by inaccurate, incomplete, or misleading information that has not been tested by the trial process, including the oath to tell the truth, and by cross-examination. Cross-examination is the method that we use in the American justice system to test for truth. It's supposed to give you the best evidence you can. Even Dr. Bodnas, he's getting in the hot seat with Mr. Reedy, right? And he's like, I'm sure you probably don't like my aggressive cross. I expect it. That's the system, right? That's your job. You're supposed to be very aggressive with me because that's how you, the jury, get to know the truth.
Right? Yeah, if you could just say that, but no, they get to say whatever they want.
Like this. You don't even know what the standard is for reasonable degree of medical certainty in Iowa, do you, doctor? Because that's a trick question because there is none. Because you heard Dr. Truth.
Or he would have bought it for scrap and then sold it on. Again, he banged up his motor running from the police. It's so stupid.
I'm certainly arguing.
Excuse me. The objection is overruled. The jury is again instructed to rely on your own recollection as to what was stated. At this point, counsel, Mr. Wilbur, I'd ask you to move on.
I'm going to what Dr. Cruz said. That he asked her, what is the standard for reasonable degree of medical certainty? And you know what her quote was? It's person dependent. It really is based on my training and experience. There is no number, right? So that's a gotcha. That's a question that had no possible answer for him to answer correctly. He's like, I don't know what the standard is. Like, well, there's a good reason you wouldn't, Doc, because there's none. It's person dependent. He told you what his standard was. He wants to be 95 to 99% sure on his opinion, right? You never got that number out of Dr. Cruz. She just said, it's whatever I feel comfortable with. But her specific exact quote was, it is person dependent. That's what I'm talking about with gotcha calls, right? That didn't help you as a jury try to decide actually relevant information about helping you test the truth. The other big sort of gotcha cross is missing in this case, right? We're hearing about this theory of like, why didn't they run down these 3 tips, right? What happened to these other 3 people? Why did they not ask Ted Roberts that, who was in charge of the missing person, right? They asked Ty Boldra about what happened. He's like, I don't know. I just get the tip and it gets passed up the chain. They ask Dr. Cruz, have you heard about this? Whatever happened with this? I don't know. Right? Nobody knows. The person that knew that was actually the person running the missing persons investigation. They didn't want to ask him that question because he had answers for it, right? You've heard about this. There was no DNA testing done. You don't know that. What you know is that there's no DNA tests that are in evidence in this case because nobody asked the question of Detective Brannigan what was done, right? It was wait and then play gotcha. That's not helpful to you. This is a big case, folks. You need to be, I understand there's a job to do. There's a client to do. You may.
Can we chip, chop, chip? And that's the whole thing is like he didn't junk his truck until the 25th when they were talking to him on the 15th, 17th, 24th. Why didn't you get shit taken care of to look at his truck then? You clearly, that they were suspect of him on the 15th, on the 17th, on the 24th. It's not like he just junked it right away the minute she went missing. He's driving it around. So I hate that they keep saying that, well, we could have looked at it properly. Well, you could have looked at it properly. You had quite enough time.
The defense obviously has no burden to put any evidence on. But when they make an argument, they are subject to the same credibility determinations as anything that the state says. They don't have to put on any evidence. They don't have to ask the question. They don't have to do that for any particular witness. But when they stand up here and ask the question of why you don't have that evidence, when they have chosen to go a different route, it's for you to learn the truth in this case. Okay. Paying Emily back. Speaking of which, however, what evidence came into this case that there was some concern about paying Emily back? None. I mean, maybe there was. I mean, maybe she said, I'm bailing Grandpa out of jail and I expect I'm going to get paid back. But again, you have to deal with evidence that actually came in this case. Nobody testified. Emily never said anything.
Yeah,
about
that's on the
that
judge
she
if it's
expected
not
that
allowed
she's getting
in.
paid back, or I was pressing
That's
Grandpa.
not
I'm like, I really could use that $500 or $1,000 or however much
They
it
were
was.
burdened.
But you have no evidence of that.
They got in trouble.
Dyer in the dumpster. Specifically brought up my folder on this because he said, you check your notes. I hope you do check your notes. When Detective Dyer testified, was specifically asked, right? So I dropped him off. He went to the dumpster on the southeast corner of the apartment complex, looked in, and then he looked in, then walked away. Not rummaged around. I suggest none of you have notes that he rummaged around because that testimony didn't happen, right? But he absolutely showed up on the 15th, and Dyer testified to that. This time was different. And that's what the suggestion for the state is why this tumultuous up and down relationship, this rocky road, this on and off again situation, this time was different. As Emily said, as Emily told us, the defendant told her, this time it's final. That's why this whole situation, why he spun up about it. Pattern of life is something that we look at when you're trying to find the win. When do you know someone is really no longer on the earth? Well, I mean, obviously when you find her dead body on the 26th, pretty good. But her pattern of life ended on the 13th. The last time anyone spoke to her, heard her voice on the phone or in person was on the 13th. You have no evidence that anyone on this entire planet ever heard her speak again after mid to late morning on the 13th. We have a text message that was sent. I would submit to you, while it's riding shotgun with the defendant, right? Submit to you, it's more reasonable. He's the one that's sending that text message. But certainly nobody heard her voice. Her daughter, you got a lot of family members here, right? Her daughter talked to her mom every day. Nothing. The HASDA agent said there were over 200 contacts early on between these two. After this date, after the 13th, 2. And again, those are texts going out. There's no conversations, 2, because he has no need to communicate with her because he knows she's dead. We call pattern of life, pattern of absence of life. You don't have a single bank transaction, human interaction, nothing, because her life has ceased to exist. This is just too coincidental also to be a coincidence. I'll put this up on the big screen. This is Exhibit 8A. Right, this is the autopsy, and I say this is too coincidental to be a coincidence, because isn't it coincidental that we have a zipper mark right next to, what's that thing right there? Oh, that looks like a zipper, right? That's what we're dealing with right there, right? A zipper right next to the injury on her body that sure looks like, and you'll get this, you'll get a chance to go back. You obviously have seen a lot more zoomed in ones, but this one's got the coat and the zipper right next to each other. What a coincidence. I mean, it's not like a really weird comparison to hold up that jacket, take a look at it, take a look at what's on her neck and say, looks pretty coincidental. Just sort of one of the final things about the phones, because Mr. Munger is correct. We don't have any evidence that, other than her dead body and her the same clothes that she was found when she was with him, we don't have any evidence of him traveling to that location, because phones don't transmit when they're off. And we've already learned that he knows how to do that.
Oh my
hours
God.
of time those are off. This is not a location that is miles and miles away. This is Crescent, Iowa. This is just halfway between the interstate and Crescent.
Yep.
This is a 10,
And
15
he's
minute drive.
telling tall
Phone
tales
off.
as tall as Bradley Yawns.
Zip up, dump a body, come back, phone on, back at my apartment. It's all the time it takes. Half hour. I don't think the defense is that he did it somewhere else, but that seems to be the cast stuff showed that he was over in Nebraska. I just bring up again to you, take a look at instruction 19, which is territorial jurisdiction, that if a body is found, a murder victim is found in Iowa, then the death is presumed to have occurred in Iowa. That avoids the state line tap dance, right? It's a presumption. You're not required to believe that that's what happened, but that is what we call a legal presumption. So the fact that she was found here, that's enough. Again, this is not a strangulation case. Dr. Cruz was looking for that, and she did a good job looking for it, and she did a good job of eliminating that. Dr. Bodden does not disagree. This is not a strangulation case. I'm getting very close to being done here. I want to sort of give an apology of sorts. I apologize for the tech problems that we had on day one. It's a struggle when you've got county computers and state court systems, and you're trying to get them all to talk to each other. You can't really control what a witness says on the stand, but you ought to be able to control your computer. And I apologize for that. I don't like to see that happen. I apologize because it's really boring. I mean, honestly, right, when you expect, closing arguments are, can be exciting. And listening, I think, to witnesses like Dr. Cruz and Dr. Bodden that are obviously, very articulate and do a good job explaining complex information. But, this is not like TV. You got to sit through days for each drudgery work. And I apologize that you had to do that. Sorry.
Just shut up.
I don't apologize for putting in the evidence that we did, because we're going to give you the good, the bad, and the ugly. That's our job.
But you.
This is a case where the defendant took 3 things. He took her life, he took her property, and then by dumping her in a ditch with some trash, he took her dignity.
I totally agree.
This is the time of justice.
This case
Mr.
is
Brammer
built
is
on
presumed
sand.
innocent and not guilty until the evidence establishes guilt beyond a reasonable doubt.
Don't put it out
This trial
there.
is
I
over.
don't want anyone to
The
know.
evidence is in. I would submit to you that we have overcome this presumption of innocence. Ilene was a mom, grandma, daughter,
We see it that way, and that's
sister,
all we can do.
She tragically lost life. I'm asking you for a verdict of form verdict number 1. What would we have? Form verdict number 9. What would we have? Form verdict number 9.
Thank you, counsel. Ladies and gentlemen, you've now heard the arguments of the attorneys. The case is being tried as concluded, and the matter is now submitted to you for your deliberation. 2 things I need to do before I send you back to the jury room. The first is I need to have Mr. McDowell and Ms. Smith report. These 2 ladies will be serving as court attendants that will be with you right outside you. I get those ladies for a second. You swear or affirm that you will take and keep this jury together in their jury room and not allow any person to speak to or communicate with them, except to ask whether they have agreed upon their verdict, not to communicate with them the state of their deliberations or the verdict agreed upon until after the same shall have been declared and received by the court or they be discharged by the court, and that the exhibits taken by you and delivered to the jury shall not be left unattended or tampered with until returned into open court. Just so say I will. Thank you, ladies. The other item is you recall back on Monday, which seems quite a long time ago, during jury selection.
We about to say on Monday, but about releasing the public, right?
Yes.
Do we have a line for that first? Or we do that?
Very brief one. Why were you going?
What?
I can't understand what he was mumbling.
Oh, and I lost ad suitability again. Funny enough, they still want me to put in ads.
That would be a jury of 12 and 1 alternate. And my purpose is just to make sure that I've got 12 people that are able to stay with me through the entire duration of the trial. Sometimes you have someone become ill, or maybe a family member becomes ill, or there's some family emergency and they're asked to be relieved. And if the court has an alternate, I'm in a much better position to grant that request. Fortunately, all of the 13 of you have remained healthy, and there's been no other family emergency. And I'm again fortunate that all of you could say and deliberate. But the law tells me it's a jury of 12 people. And so I'm going to announce and then release the alternate now. And I want this individual to know that before she leaves today, she needs to provide her cell number to Ms. McDowell or Ms. Smith, and I will personally call the individual when a verdict is returned and let them know what the verdict was. Our alternate is Michelle Mabbitt. So Ms. Mabbitt, I thank you so much for spending the week in hearing this case. Again, as I stated on Monday, I think jury service is perhaps the best example of the rule of law at work in our society, but it only works when people like you spend a week out of your daily lives. And so again, on behalf of the court, thank you for your service. And don't forget to provide Claire or Olivia a number and I'll call you. All right. And with that, Ms. McDowell, Ms. Smith, jury is in your hands. Have them back to the jury. I want to make sure that Tish has an opportunity to gather the evidence and get it to the jury. And my thought is that it may time-wise be more efficient if I have you just back in chambers in 15 minutes to make some record, but I'm going to make some record on the most recent sidebars. If you'd rather do it right now, I'm fine with that too. All right. let's take care of it.
Oh my god.
Yeah. What if this lady has to come back? But again, he doesn't think about the cameras.
And having to do with
I
Mr.
think
Brock.
Mr. Munger's action to Mr.
You're
the defendant, quote, worse friend, in an argument by a number of objections. The gallery was standing and moving toward the exit doors, and I wanted them to know that they're free to leave. Yeah, this is a public hearing, public trial, and so anyone that wishes to stay, they're free to stay, and some folks have remained. The court, again, wishes to make record on a number of objections during the rebuttal argument of Mr. Wilbur. There were two, and I'm going to take them separately. The first was,
Yeah, I don't get why she couldn't stay in the
in an
courtroom like
argument by
Ultimates normally do, but they
the
must
state's
believe that
attorney.
it's over in 5 minutes.
Yep.
that the jury had heard
Come on.
argument from the defense attorney, and defense attorney referenced Mike Brockman as, quote, worst scapegoat ever, end quote, and then was arguing in an effort to rebut the defendant's suggested theory, as I understood it. The objection at the sidebar was overruled based on the fact that we do have evidence from the defendant's own statements during the trial referencing Mr. Brockman, and the court allowed the rebuttal argument. That's the court's summary of the sidebar. I'll allow both counsel an opportunity to make any recollection, or excuse me, any additions or corrections of the court's summary or any other record they'd like to make. Mr. Wilbur?
I think your summary is accurate, Your Honor.
Mr. Munger?
Judge, my objection was based upon Mr. Wilbur about to get into arguing about opining about the credibility of a witness, which is in direct violation of this court's motion to eliminate, about giving an opinion as to the credibility is within the purview of the jury only. So that was the reason for my objection. Otherwise, the court summarized the sidebar appropriately.
Great. And then I also would add then, after my direction to Mr. Wilbur, that he continue but to move on from that and not be opining about credibility. He did.
I don't believe I opined about Mr. Brockman's credibility or anybody else's. It was the the credibility of the argument having to do with
I think
Brockman.
Mr. Munger's reason of approaching the bench was he wanted to nip it in the bud before you got there.
And also calling him a straight shooter. I don't know what other connotation a straight shooter has other than, hey, you got to believe him.
Yeah, you referred to him as
Any other record by either counsel on that?
No, Your Honor.
The second
Good old-
sidebar, again, was during rebuttal argument. And this was argument made by the state's attorney, Mr. Wilbur, concerning or revolved around defendant's cross-examination and his reference to instruction that cross-examination, as well as the entire trial process, is our tools to reach the truth.
What?
Mr. Wilbur's reference was concerning questions of, I believe it was Sergeant Baldra, concerning tips that had been received by the police department and the prosecutor's statement that that was not something that Mr. Boulder was aware of and could not respond further, but that was something that could very well have been asked of Sergeant Roberts, who was leading the investigation of the missing person. And it was referred to as got you cross-examination. There was a separate reference a few moments later concerning a similar type
Lack
of
of
argument
interest.
revolving
He'll
around
stop yammering later than
Deputy
jury will be back with a
Detective Brannigan and DNA
verdict.
evidence. The court's concern.
Well, why are you going over this crap now? You're going to change your mind.
I have a football match.
Along with a number of matters was burden switching, and the court made clear to the state's attorney that he needed to make a statement that confirmed that the state has the only burden in this case, and the defendant has none. That's the court's summary of the sidebar. I'll allow the state's attorney and the defense to make any further record. Beginning with Mr. Wilbur, is that a fair and accurate summary of the sidebar?
I think that's accurate, although I think there was one other, just to be fair, issue that Mr. Reedy was taking. That's when I said he was playing gotcha cross-examination with regard to there being a lack of a standard for reasonable degree of medical certainty, which Dr. Cruz had opined or had given the answer that it's actually person-dependent. So he was upset about 3 different statements of gotcha cross, but your summary of the sidebar is accurate. Do you want me to make further record now?
Any record you have?
Oh, I would just say I believe that I was making fair comment on defense argument, and any commentary I made was invited by the defense. That's my position.
Either defense counsel can respond.
Judge, my position is that he has no right to say we had a duty to ask anything. What we choose to ask is our right. He cannot then say, but we should have asked. We should have done. We could have done. Any of those things are improper burden shifting to us.
That's
he does
right.
not have that right to say we should have asked about the DNA. We should have asked about the fingernail. We should have done anything. Any one of those is improper, and it's not good enough for him to get to make the comments and then come and say, "But it's our burden." He's already made the comments. He's made it to the jury of saying, "Oh, what the hell? Why didn't they do something?" He's already done that. That's the improper part, Judge. That's
sidebar. He said that the defense could just have asked the
court's
question. They should just have done this. They should just.
I overruled the objection, but did state to all counsel that I believe that the state's attorney was getting dangerously close to a burden switching.
That's
which was
12 minutes.
Oh no, but this is like going on right now. Okay.
From the defense counsel,
and
I then directed the prosecutor to make clear in his argument
during this they have
that
this is just
the state has the burden
of the sidebars.
And as this jury has heard from me,
okay, I got to set up my next stream so you can dump
if not more, and are included in my instructions.
Watch football.
That
right.
The state has the burden to prove everything in this case. And for all those reasons, the objection on both sidebars were overruled. Any other record needs to be made at this point?
Maybe I'm just thinking housekeeping, Your Honor. I don't know if we have to do this on the record, but what's going back to the jury? How are we going to handle that? I know we had some brief discussions yesterday. My understanding is everything's going back except for the videos. But then we have to figure out a way if they request to watch those, how we're going to get that done. Is that your understanding that we're going to keep the videos, or are we going to just send it all back and just don't give them a player unless they ask? I don't know if we ever clarified that.
I do have a blank laptop back there. You know, previously I had been able to plug in the flash drive to it. So there's nothing on my computer.
I don't think we have any evidence that's on a flash drive, though. Do we?
We certainly have everything that's in a video we have on the laptop. So there's no question that we could take, it wouldn't even take that long. We could do that for a flash drive. Option 2 is figure out an external DVD. Do we have an external DVD in the office at all? Yeah. So we could give them an external, DVD player, and then they can just play the discs themselves. I think that's cleaner.
Option number 2.
I agree.
I do too.
I agree.
If we have that external disk drive, then maybe the cleanest thing to do is provide them with everything now.
Perfect.
Claire, from what you're telling me, you did find a blank or a stripped down laptop. There's nothing on it. And is that in the jury room now?
It is in the jury room, and I have it all set up to go. However, I do not think it plays DVDs.
No, we have an external.
We have an external, yeah.
Okay.
Almost no laptop. They don't have disk drives anymore like that,
Okay.
but
And it should have a USB. Yes,
You gotta talk one at a time.
apologies.
my turn.
Sorry.
Did you hand her external disk drive and it has a USB connection?
Yes, Your Honor.
All right. All of the evidence will be going back with the jury at this point, and I don't have to worry about the jury sending a question out, asking me for access to the videos. And Claire, I don't think I'd do anything more than provide them with the evidence. And if they ask any other questions about using the disk drive or whatever, then we'll respond to them. But otherwise, just provide everything that you've got, and you've got the disk drive there, and the laptop's already there as well.
Fair to say the laptop has Wi-Fi disabled?
Correct.
Okay.
Everything is. It's a clean, which is what I requested anyway, but I think that's what it is.
There's one that we use for regular travel. There's no internet. Nothing.
Perfect.
All right.
Great. Thank you.
Any other?
I have
Mr.
set
Reedy
it
wants to
up,
clarify
Dave. You
that
can
no
just
digital
turn on your
pictures are being
stream,
given to
and
the jury.
I can get on.
Physical copies.
That is
Just the physical copies are going back,
That's weird that they're sending all
which
of
is, I
it.
think, something we stipulated a week ago, or at least talked about
Claire,
it.
or making sure.
Okay. With that, we're off the record, and Tish and Claire take care of things. Great, thank you.
Does council wanna do this with us, or are you guys okay with it?
Well, Jamie, as always, it was a pleasure. But it's the weekend, so you need to go to the other dad. If he can just start up the car and get running. He's always late when he has to pick you up. But tell him there must be a Happy Meal in it for you today.
You better.
Yeah.
Still waiting.
Yeah, take you to the zoo or something fun.
My goddamn.
But he set it up for in 7 minutes. Well, we're going to talk until Dave's get ready to go, so I can dump you off over in his channel, and he's ready to giggity go. Yeah, I'm not sure I'm going to enjoy my game. We've been playing really badly, but if we win tonight, we will be in the European Championship next year. So
What game is it?
Denmark
Okay.
playing. Who are we playing? I should know this. It's not Kazakhstan. They played San Marino earlier. Bum, 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 bum. Luftens helte. We are playing Slovenia. Oh, it doesn't start till late today. Well, then I can get some dinner too, because it's 20 to 9 my time. Some marriages are really happy when there's this constant little tension, but then we got the kid, and it just didn't work out. He was always working, I was always working. We couldn't decide who should be having Jamie. It says 9:35 on. Well, yeah, but who's a better team? Denmark is the bestest team in the world. No, we're not. We're a really bad team right now. But yeah, what do we think about the closings, Jamie? Let's get back to the bread and butter of this channel. Craziness. I hated it. They were way too long. They have been wasting close to 4.5 hours on closing arguments.
Yes.
And I thought it was really shady the way they did the rebuttal.
Yes. I am just, first of all, I feel like we always say this every time we watch something. You shouldn't be going on and on and on during a closing. Your evidence and your case should speak for itself.
Exactly. And the problem is, the case is really bad when we look at it.
I mean, it looks bad on both sides. It really does.
Yeah.
We have to look at what the state has proved.
Yeah, and beyond a reasonable doubt, we have to keep that in mind. Beyond a reasonable doubt, we could always. Well, he probably did it. But have they proven it beyond a reasonable doubt? Their crux are the Weekend at Bernie videos that doesn't show any injuries, doesn't show anything other than she could have been asleep, she could be dead, she could be angry, she could be just sitting watching out the window listening to her tunes. It's not enough for me to say, oh, I saw her leg, and the way he took the bag and put it over to her, to me that didn't scream, I'm sitting next to someone I just beat to a pulp.
Yes, exactly.
So yeah, but everyone, Jamie has to go to her other dad, so sadly,
for first.
but I'll send you over to Jamie's new dad as well. Everyone, thank you so much. Thank you so much for watching, and we'll see you down the road, and I'll go watch a little footy foot. Bye.
Bye.